May I please, Lordship? May I take indulgence of this for Lordship? Item number 12, Lordship. Can it be taken any time during the day? Actually, it has not been listed. Any up to, Lordship, if possible. Lord. I was waiting. It has not reached. It actually in the if bail is also been taken, then
There are 21 matters in the first list. Item number 12, we should reach. Don't worry. Let us see.
okay. Let's see. If they are for listing IL Lordship and they connected appeal Lordship, and I is pending Lordship. Can it be
I was last listed when?
when the 3 weeks time was given to the
When was it last listed?
25/9 Lord, 24.
25/9.
Lord.
Thereafter?
And 3 weeks time was given to the respondent to file the objection. Lord. But they have filed yet to be held. But the Lordship appellant is 75 years old. Lord. When
Okay,
earlier I have
next Wednesday. Next Wednesday.
published.
Madam, try to file the objection, whatever is.
Lordship, similar prayer, Lordship, for listing of a IA, Lordship, next week, any day.
Pending.
Lordship, in connection of a.
What is the stage of the IA?
Lordship, it was posted for orders last pocket.
When was it last listed?
It was Lordship 23/10/2024.
23/10.
Supposed to list last week.
23/10. Today is what?
Yes, Lordship,
Okay, next Wednesday.
Lordship, in this case, Lordship, the LCR was called for on Lordship 17/10/2023. And till date, Lordship, LCR not arrived. And in the meantime, Lordship, they have filed their objection. They have filed their objection
In the IA.
in the IR.
POXO matter.
So,
Let the LCR come.
Lordship, Sarkis also,
What about the aspect of service?
if I could not transfer the office note, Lordship.
Did you take steps?
Lordship, we have taken steps on 18/10/2023.
There is no office note regarding,
So, officer
madam,
entered.
regarding the aspect of service. You have to
Lordship.
take instructions.
Let them take first step.
Already take, Lordship,
You take first steps. okay?
Lord.
I-
As per the office note dated 12/10/2024, the LCR which were called for by this court wide order dated 17/10/2023 is yet to be received. Full stop. The said requisition was made only on 6/11/2023. When was it admitted?
Admitted on Lordship 17/10/23.
6/11 only it was sent, the requisition. Today is what? 14th. It's natural.
6/11, Lordship, 23, Lordship, probably 6/11/23, Lord.
Oh, right, you're right. Oh, 6/11.
Now 24, Lord.
6/11/20, you're correct. 6/11/2023, huh? 24 6/11/23. For the para. Office to issue immediate reminder for requisitioning the LCR. Full stop. As regards the aspect of service of notice upon the respond number 2, as no office notice there, comma, learned counsel 3, Ayush Chaudhary is directed to take fresh steps for service of notice, which is to be routed through the office of the Public Prosecutor Assam. Full stop. On the next date, Ms. B. Bhuya, learned APP Assam, shall obtain instructions regarding the aspect of service of notice upon the respond number 2.
Deeply, Lord.
List after 3 weeks.
Deeply.
But you take the steps today itself so that they can transmit it.
Procedure.
How many appeals are there?
Total 3 appeals are there.
3 appeals, 2.
3 appeals,
Okay.
4 appeals.
Arising out of the
Oh.
same,
Same judge.
okay. You represent whom?
I'm representing Lordship appeal in appeal 360, 2 appellants, Ram Milan and Abdul Kalam, and 393 Saurabh Khan. And senior counsel HRS is appearing in appeal number 288, Mojibur Rahman. He's coming, my lord. Let me start.
Yes, against whom? NCB?
Yes.
NCB. So Mr. Kyle is there or not?
Okay. Yes, coming, lord.
Yes, Mr. Agarwal?
That's a matter after that.
Okay.
So I still telling that it will take time.
Yes.
Let us see what happens. I'm here, no. I think it's different another court. I have a hearing. Let it continue.
All right.
If we then I make a mention at
Okay, we'll have some other dates if there's some difficulty, because that matter will take some time.
Huh?
Your matter will obviously take some time. That
Yes, sir.
reference.
appeal is also. I've been appointed as amicus.
Amicus, okay.
So, my lord, 4 appellants before your lordship.
Just a minute, please. Mujibur is represented by HRA Chaudhary.
Yes, lord.
এইটো নহয়, এইটো কাটিছে, এইটো কাটা আছে, এইটো পুৰণি আছিল যে কিছুমান বস্তু নাছিলে। Ram Milan and
Ram Milan and Abdul Kalam, lordship, in appeal number 360,
Abdul Kalam.
lordship.
And 393
393, lordship, Saurabh Khan.
you are representing it.
Yes. Regarding the case, lordship, I have placed one small synopsis on last occasion. Record. My lord, may I start?
Just a minute. Synopsis.
Regarding date of arrest and all, and the name of the accused, contraband recovered from whose possession, what, and the witness names and their designation.
Okay.
Lordship.
Just
In this case, lordship,
a minute.
lordship, I have one copy only right now. Okay. They are inside the right now the 8 years, 6 months, 7 days to dealer. From the date of arrest, lordship, and after appeal, they are inside 5 years, 6 months, 23 days.
You'll continue.
But in this case, as per information received in page number 1, NCB 1, it's exhibit 3. On the PW3 received an information, Lordship, on 6/5/2016 that 2%, page number 1, Lordship.
Yes.
On 6/5/2016, my casual informer informed me that 2 persons, namely Muhammad Abdul Kalam and Majibur Rahman, will be going to deliver a consignment of morphine and opium to other persons, namely Saurabh Khan and Ram Milan, near entrance of Indira Gandhi Stadium, Torusuzai, Guwahati at 7 a.m. on 7/5/2016. He requested to intercept them. On receipt of this information, Lordship, office order was prepared. That is exhibit 4, Lordship, at page 156. Then the team was prepared and they rushed to the place of interception next day morning. And next day morning, they found one Scorpio vehicle was there, and then PW3 deposed that one informer indicated that this is the vehicle, and thereafter one truck arrived there, which mentioned in the NCB 1 MN04A 1960. That truck arrived, and then after arriving the truck, the person who were boarded in the Scorpio vehicle, they came out. Then the 2 persons also came out from the truck, and from the truck some contrabands they collected and then handed over the 2 persons who were inside the Scorpio vehicle. Thereafter, informer indicated those are the persons, and accordingly they intercept at that place. Then recovery was made, search and seizure was made there, and then notice under 67 issued to them, and statement recorded at the place of occurrence as stated by the PW3, but the accused stated that they recorded their statement in their office. And then, Lordship, what happened? Samples also collected at the spot as per the position of PW. And they have stated that 2 independent witnesses they found nearby the place before intercepting the person. Then one is Neela Braspa and another is Neela Braspa. And then two person, Lordship, at no point of time they examined by the prosecutor. They were not examined by Lordship. They issued summon. After receiving the summon and found the address correct, the person never appeared before the trial court during the trial, Lordship. So thereafter, judgment pronounced, Lordship, and conviction was for 20 years. So in this case, Lordship, PW1 is the FSL, Lord, FSL expert. As many as 6 witnesses examined, including the FSL expert, Lordship. FSL expert, the position as at page 3. And 2 DWs also, Lordship. So thereafter, PW1 is page 3, Lordship. Here in this PW2, I think, Lordship, I need not to read all the deposition of the PW2. PW1 is stated that he received the samples and thereafter he examined it and found that these are the positive of morphine and opium, Lordship. And your recovery of opium 50, Lordship, it is important. Recovery of opium is 54.648 kg and morphine is 2.60 kg. These are the recoveries. Then he confirmed that these are the positive of morphine and opium, Lordship. So thereafter, Lordship, PW2 at page 4. She is the superintendent of department lordship, and she received the seized contraband and kept inside the godown. At page 4, Lordship. May I read, Lordship?
Please read.
On 6/5/2016, I was working as superintendent in Narcotic Control Bureau, Guwahati. On that day, one Pavan Vaisane, intelligence officer, NCB Guwahati, informed me in writing that two persons, namely Muhammad Abdul Kalam, Muhammad Mujibur Rahman, were going to deliver of consignment of morphine and opium to other persons, namely Saurabh Khan and Ram Milan. The place of delivery of the consignment, as informed was near the entrance of Chorusozai Stadium, Guwahati. The time of delivery of consignment was 7 a.m. On the next day, after receiving the information, I acknowledged the signature of intelligence officers and forwarded the information to our Zonal Director, NCB Guwahati office. After receiving the secret information, the Zonal Director, Praveen Kumar, issued a office office order on 6/5/2016, directed some of the officers and sepoys to proceed to Indira Gandhi Stadium, Lakhra, Guwahati, for the purpose of search and seizure of narcotic drugs, and it is also intimated that in case of recovery of narcotic substance of case number so and so and Praveen Basane will be the seizing officer. Exhibit 3 is the written down information, wherein Exhibit 1 is the signature of Praveen Basane. I know his signature. 3-2 is my signature. 3 is signature of the General Director, Dr. Praveen Kumar. I know his signature. Exhibit 4 is the office order issued by Praveen Kumar, General Director, NCB, wherein Exhibit 4 is the signature of Praveen Kumar. I know his signature. I also the in charge of NCB Godown, and on 7/5/2016 at about 5:45 p.m. Sri Pavan Vaisane, seizing officer, came to me along with the seized item and samples of the seized items. He handed over those samples and articles to me, and as godown in charge, I kept all those items and samples in godown of the NCB and issued a godown receipt to Sri Pavan Vaisane. Exhibit 5 is the godown receipt number 1, wherein 5-1 is my signature. On 8/5/2016, again Pavan Vaisane received back the seized items and samples for taking into the court for the purpose of showing those seized articles to the court. Exhibit 6 is the godown receipt number 2 in NCB crime number 4 of 2016, wherein Exhibit 6-1 is the signature of Pavan Vaisane. I know his signature. On that very day, that is on 8/5/2016, after producing all the seized items and the samples in the court, Pavan Vaisane returned back it to me, for which I issued NCB godown receipt number 3 that dated 8/5/2016 in NCB crime number 7. Exhibit 7 is the said receipt, wherein Exhibit 7-1 is my signature. On 9/5/2016, Pavan Vaisane received the original samples 7 in number from me for sending those samples to the FSL Guwahati. Exhibit 8 is the godown receipt number 4, wherein Exhibit 8-1 is my signature, is the signature of Pavan Vaisane. I know his signature. On that very day, Pavan Vaisane submitted compliance report under Section 57 of NDPS Act to me. Exhibit 9 is the said compliance report submitted by Pavan Vaisane, wherein Exhibit 9-1 is the signature of the Pavan Vaisane and Exhibit 9-2 is my signature. I was not in the search team on 7/5/2016. When Pavan Vaisane produced the seized articles and samples to me, they also brought the 4 accused persons to the office, and I was there. I saw their faces. Today, they are present in the dock. I can recognize them. Cross. In Exhibit 3, no reference number has been given. I acknowledge the confirmation, and after making it, I forwarded it to the General Director, and I did not give any separate forwarding letter. Neither me nor Pavan Vaisane or the General Director put their official seal in Exhibit 3. It is not a fact that on 6/5/2016 at about 5:30 p.m. or any time, we did not receive any information. Exhibit 4, there is no seal of Journal Director. In Exhibit 4, the name of the accused persons have not been mentioned and the name of the contraband items are also not mentioned in Exhibit 4. In Exhibit 5 to 7, I received 6 sealed packets marked P1 to P6 containing sanctions. In Exhibit 5 to Exhibit 7, I also received one sealed packet marked as Exhibit 7 containing 2.5 kg of morphine. Exhibit 7, the facsimile of the seal is absent. I received 2 yellow envelopes. On the envelope contain documents and other envelope contain currency, and I mentioned the same in my godown receipt as because those were unmarked. I did not receive any other articles, documents, and currency beyond things mentioned in Exhibit 5 and 7. I put my signature only on the first page of compliance report submitted by Pavan Baisane under Section 57 of NDPS Act. I did not receive any extra forwarding letter with the report under Section 57 of NDPS Act. It is not a fact that I did not receive any information on 6/5/2016. It is not a fact that on 7/5/2016 in the morning, the accused persons were arrested. It is not a fact that the accused Saurabh Khan and Ram Milan have not been arrested on 6/5 from Paltan Bazar. It is not a fact that after arresting the accused person on 6/5/2016, we implicated therein these false cases subsequently. It is not a fact that in Exhibit 3 is a manipulated document. It is not a fact that I am deposing falsely at the interest of my officer. It is not a fact that the accused persons are not involved in this case. At the time of receiving articles, we maintain godown register. I have neither seen the godown register in the court today, nor any copy of the godown register was submitted in the court. Prosper, Abdul Kalam and Mujibur Rahman, I only acknowledge the information received from the junior officer. I did not mention the date, time when I received the information from my junior. I do not know about the Panchnama as the same was prepared by Pavan Baisane. I do not know about the final complaint submitted by Anjani Kumar. I was not present at the time of search and seizure. I have no personal knowledge about the search and seizure. Exhibit 5 to Exhibit 7 are computer printed copy. Exhibit 5 to 7 are the original godown receipt. It is not a fact that those are certified to be true copy of original godown register. Exhibit 5 to 7 are the original signature and seal, and according to me, there is no need for giving the further certificate regarding original copy. As such, I did not append any certificate at the bottom of the Exhibit 5 to Exhibit 7. I have already stated that I was not present at the time of search and seizure, and as such, I cannot say whether P1 to P7 are seized from accused persons or not. I only received the articles which has been produced before me. Exhibit 9, that is the report under Section 57 of NDPS Act, was not produced before CGM before submitting to me. It is not a fact that Exhibit 9 report under Section 57 of the NDPS Act was not prepared in time. We did not produce before the CGM, and ultimately at the time of filing offense report, we tagged the offense report. It is not a fact that the accused Abdul Kalam and Mujibur Rahman were not involved in the present case, and they were arrested from somewhere else and falsely implicated in this case. This is the superintendent of NCB Lordship, and she has received the contraband after seizure. So she has some role. I will come to that later on. So her role limited here. She concluded here on. Further, she has not done anything, Lord. And in this case, only PW3 is the person who has done everything. and there is nobody put signature. The officers though mentioned 10 numbers of officer detained by the zonal director. They were present. They have mentioned these persons mentioned, and then Lordship, they did those persons signature of on the papers which was prepared on the spot. So only this person is the person, Lordship. We have, it is a long deposition. He is the main person, Lord. So PW3 seizing officer Pavan Baisani. On 6/5/2016, I was working as intelligence officer in Narcotic Control Bureau, Guwahati. On that day, at about 5:30 p.m., I received an information from my informer that two persons, namely Muhammad Abdul Kalam and Mujibur Rahman, would be going to deliver a consignment of morphine and opium to two other persons, namely Saurabh Khan and Ram Milan, near Indira Gandhi Stadium, Saraswati, Guwahati. On that day, immediately after receiving the information, I reduced the same into writing. It was informed to me, my superior, namely Tulika Morang, Superintendent NCP Guwahati, generally. After that, an office order was issued by Zonal Director, namely Praveen Kumar, deploying 10 persons for the operation. So the person's name not mentioned by him. I myself was the seizing officer as per the state office order dated 6/5/2016. Exhibit 3 is the NCB 1, reduced into writing, wherein Exhibit 3(1) and 3(4) are my signatures. Exhibit 4 is the office order issued by Zonal Director. Exhibit 4(1) is the signature of Zonal Director. On the next day, that is 7/5/2016, as per office order, we left NCB office at 6 a.m. After reaching near Indira Gandhi Stadium, Saraswati, Guwahati, we approached two persons who were walking on the road and told them about the information available with us. So these are the persons. So we also give our introduction of the member of the team and requested both of them to be independent witnesses of the process of search and seizure, if any. When we reached the spot along with independent witnesses, one white color Scorpio vehicle bearing registration number was seen parked on the service road. At about 6:30 a.m., one truck bearing registration number reached near the Scorpio. After that, two persons from the Scorpio came out and went near the truck. The two persons who were sitting near the truck also came out, and these four persons discussed something for about 1 minute. At that time, the team was indicated by the informer that these were the four persons who were trafficking the opium and morphine. Regarding informer, Lordship, nowhere stated. In the team also, in the exhibit 4, not mentioned.
Is it required?
Not required, but informer name need not to disclose. It is not required, but the one informer is also with us that needs to require. Informer name need not, then there is no necessity to disclose the name of the informer. But along with the team, the informer was also there. That is the duty of the officer, Lord.
No, you said at that time the team was indicated by the informer.
Yes, it is only this person has stated. Informer indicated. Informer was there. That is not mentioned in anywhere in the final complaint also. Informer was no, in the deposition.
And the gist of the information received, it was there.
Information received. Thereafter, along with the team, informer went with them. That is not mentioned by any witness. So
well, who else will mention? He is the main person, this PW3. He has said, after that time, the team was indicated by the informer that these were the four persons.
It is correct. The information received from an informer regarding a truck with specific number, but with the team, the informer was also with them. That is not mentioned in the office order. And the other person along with him who went to the place of occurrence, that is not mentioned. So, may I proceed, Lord? At that time, the team was indicated by the informer that these were the four persons who were trafficking the opium and morphine. After that, one person entered the cabin of the truck and handed over few polythene packets to the persons who were standing near the truck. We rushed towards the truck and Scorpio when we reached near the said vehicles. All the 4 persons were standing near the said truck with polythene packets in their hands. Thereafter, we introduced ourselves to them and we told them about the information available with the team. On asking the 4 persons, they identified themselves as Muhammad Abdul Kalam, Mujibur Rahman, Muhammad Saurabh Khan, and Ram Milan. These 4 persons were present near the truck. During body search of the 4 persons and their belongings, provisions of Section 100 CRPC were followed. Before conducting body search, I served notice under Section 50 of NDPS Act to all the 4 persons. They acknowledged the same and gave the written consent of the body search. Exhibits and also are the acknowledgement copy of the body search issued to them under Section 50 of the NDPS Act. Thereafter, the said 4 persons gave written consent in presence of the independent witnesses. The written consent of the 4 persons specifically stated that they did not need the presence of any magistrate or any other gazetted officers at the time of any time of body search. Exhibit transactions is relevant consent given by accused Saurabh Khan in his own handwriting. Then these are the exhibits, Lordship, regarding the consent of body search. Then on opening the plastic bags carried in both hands by accused Saurabh Khan, dark brown color sticky materials was found packed in 2 packets wrapped by brown color sellotape and kept in white polythene packets. A small quantity of dark brown color sticky materials was taken out from both the packets and tested with the help of drug detection kit brought by the NCB team, and both materials gave positive for opium. Both white plastic bags were marked as C1 and C2, and packets containing dark brown color sticky materials were marked as P1 and P2. On weighing with the help of digital weighing machine in presence of 2 independent witnesses and 4 suspected persons, and weight of P1 and P2 was found to be so and so respectively. The opium was seized in presence of 2 independent witnesses. 4 accused persons drew 1 sample in duplicate of 24 grams each and marked as S1 and D1 and S2 and D2 respectively. All the 4 samples were duly packed in polythene and then kept inside the envelope, and all samples and seized dark brown color sticky material suspected to be opium was sealed with NCB brush seal number 1 and properly labeled, and signature of the independent witness and 4 accused persons and seizing officer were also taken on them. This is the main crux of the case. Same is also similar. I'll read that. But Lordship, samples collected on the spot. This sample produced before the magistrate after collecting on the spot, and this has forwarded to the FSL Lordship. So we'll come later on that part. The polythene bags carried by Muhammad Mujibur Rahman was searched, and opening the said bag carried by him, dark brown color sticky materials was found in 1 packet wrapped by brown color sellotape and kept in white polythene. A small quantity of the dark brown color sticky material was taken out from the packet and tested with the help of drug detection kit, and the material gave positive color for opium. This white plastic bag was marked as C1, C3, and packet containing dark brown color sticky material was marked as P3. On weighing, the sticky was found to be 10.0, so then opium was seized. Then we drew 1 sample in duplicate of 24 grams each in presence of the independent witnesses and 4 accused persons and marked as S3 and D3. The samples were duly packed in polythene and then kept inside on the envelope. All the samples and seized dark brown color sticky material suspected to be opium was sealed with NCB brush seal number 1 and properly labeled and signatures of the independent witnesses and four accused persons and a seizing officer was also taken. The polythene bags carried by Ram Milan were searched, and on opening the plastic bags carried in both hands by Ram Milan, the dark brown color sticky materials was found packed in 2 packets wrapped by brown color sellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from both the packets and tested with the help of the drug detection kit, and both materials gave positive for opium. Both white plastic bags were marked as C4 and C5 and packed containing the dark brown color sticky material were marked as P4 and P5, and weight of P4 and P5 were found to be 100 kg respectively, and the opium was seized. Then, in presence of 2 independent witnesses and 4 accused persons, drew 1 sample in duplicate of 24 grams each and marked as S4 and S5 and D5 respectively. All the 4 samples were duly packed in polythene and then kept inside on the envelope. All the samples and seized dark brown color sticky material suspected opium was sealed with NCB brush seal number 1 and properly labeled, and signatures of independent witnesses and all 4 accused persons and seizing officer was also taken. The polythene bag carried by Mohammed Abdul Kalam were searched, and on opening 1 plastic bag carried by Mohammed Abdul Kalam, dark brown color sticky materials was found packed in 1 packet wrapped by brown color sellotape and kept in white polythene. A small quantity of of dark brown color sticky material was taken out from the said packets and tested with the help of drug detection kit, and the material gave positive test for opium. The white plastic bag was marked as C6, and packet containing dark brown color sticky material was marked as P6, and on weighment of the P6 was found 3.878 kg gross. The suspected opium was seized, and then in presence of the independent witnesses and 4 accused persons, drew 1 sample in duplicate of 24 grams each and marked as S6 and D6. The samples were duly packed in polythene and then kept inside as envelope. Both the samples and seized dark brown color sticky material suspected to be opium was sealed with NCB brush seal number 1 and properly labeled, and signature of independent witnesses and 4 accused persons and the seizing officer was also taken. On opening the second plastic bag carried by Mohammed Abdul Kalam, brown color powder was found packed in 1 packet wrapped by brown color sellotape and kept in white polythene. A small quantity of brown color powder was taken out from the said packet and tested with the help of drug detection kit, and the material gave positive for morphine. The plastic packet bag was marked as C7, and packet containing dark brown color powder was marked as P7, and on weighing the P7 was found to be 700. The suspected morphine was seized. Then, in presence of independent witnesses and 4 accused persons, drew 1 sample in duplicate from 5 grams each and marked as 7 and D7. Both samples were duly packed in polythene and then kept in the inside the envelope, and both samples and seized dark brown color powder suspected to be morphine was sealed with brush seal number 1 and properly labeled, and signature of independent witnesses and 4 accused persons and a seizing officer were also taken. During personal body search of Mohammed Abdul Kalam, 1 PAN card in the name of Mohammed Abdul Kalam and Indian currency of rupees 5,000 were recovered. During personal search of Mohammed Saurabh Khan, 1 PAN card in the name of Saurabh Khan and cash of Indian currency of rupees 7,000 were recovered. Personal search of Ram Milan, 1 PAN card in the name of Ram Milan and cash of Indian currency rupees 3,000 were recovered. And during personal search of Mohammed Mujibur Rahman, some copies of the documents related to ownership of the truck and cash of Indian currency of rupees 2000 were recovered. All the recovered documents during personal search of all 4 persons were kept inside as envelope, and money was kept in another envelope duly marked and sealed by NCB Brazil number 1 and properly labeled, and signatures of independent witnesses, 4 accused persons, and the seizing officer was also taken. Both vehicles, that is truck and the Scorpio, were searched. On searching the Scorpio, we found that a special cavity has been made and the vehicle number so and so and so. On inquiry, accused Saurabh Khan admitted that the vehicle so and so is registered in his name. He also told that he had made this special cavity for trafficking of drugs. Then the said Scorpio was seized, and on inquiry, it was told by one Mojibur Rahman that the truck number so and so was registered in his name. He also told that he had brought the said consignment of opium and morphine from Impal in his said truck, and the said truck was seized. And copy of insurance premium slip of truck number so and so issued by United India Insurance Company Limited and public carriers permit issued by the Transport Authority Thaubal against the vehicle numbers and so were also seized. On inquiry, all 4 accused persons admitted their involvement in trafficking of drugs. They also revealed that they were doing illegal trafficking of morphine and opium for the last many years for monetary benefit. Thereafter, on reasonable belief that an offense has been committed under section so and punishable under the entire consignment believed to be opium and morphine was seized under section 43 of the NDPS Act as amended. The search cum seizure list and panchnaama were prepared on spot. The seizure process were completed at about 12 p.m. on 7/5/2016 in presence of independent witnesses and 4 accused persons. Exhibit 18 is a search cum seizure list dated 7/5/2016. Exhibit 18(1) is my signature. The search cum seizure list was prepared in presence of independent witnesses and 4 accused persons. Exhibit 18(2) is the signature of accused Saurabh Khan. 18(3) is the signature of Mohammad Mojibur Rahman. Then these are the signature exhibited. Exhibit 19 is the panchnaama dated 7/5/2016, and exhibit 19(1) to 19(11) are my signature, which was prepared by me in presence of witnesses and the 4 accused persons. After that, notice under section 67 of NDPS Act was issued to the 4 accused persons on 7/5/2016. Exhibit transons are the copy of the notice under section 67 of NDPS Act issued to 4 accused persons, namely transons respectively. The notice under section 67 of NDPS Act issued to them for regarding the voluntary statement of the 4 accused persons. The voluntary statement of the accused Ram Milan was recorded on 7/5/2016. As per statement, he stated that he has been involved trafficking to illicit drug for the last 3 years for monetary benefit. Exhibit 24 is the voluntary statement of accused Ram Milan in Hindi language. Exhibit 24(1) to Exhibit 24(4) are my signatures. Then the signature of Ram Milan. The voluntary statement of accused Mojibur Rahman was recorded on 7/5/2016. As per statement, he stated that he has been involved trafficking to illicit drug for the last 3 years for monetary benefit. Exhibit 25 is the voluntary statement of accused Mojibur Rahman in English language. Then these are the signatures. The voluntary statement of accused Abdul Kalam recorded on 7/5/2016. As per statement, he stated that he has been involved trafficking to illicit drug for the last many years for monetary benefit. Exhibit 26 is the voluntary statement of Abdul Kalam in English, and then the signature exhibited. The voluntary statement of accused Saurabh Khan recorded on 7/5/2016. As per statement, he stated that he has been involved in trafficking to illicit drug for last 3 years for monetary benefit. Exhibit 27 is the voluntary statement of Saurabh Khan in Hindi, then the signature exhibited. After recording their voluntary statement of 4 accused persons, I arrested them in the contravention of provision of Section 8C of NDPS Act and punishment under Section 21C, 17C, and 29 NDPS Act. So, Exhibit 28, 29, 30, and 31 are the copy of memorandum of arrest issued to Saurabh Khan, Mujibur Rahman, Ram Milan, and Abdul Kalam in connection with NCB crime number 7. After that, we returned to NCB office along with seized articles and 2 vehicles to the NCB office and 4 accused persons. I deposited the seized article P1 to P7, seized documents, samples S1 to S7, D1 to D7, and currency transferred to the godown in charge, probably. The godown in charge issued to the same with acknowledgement. Exhibit 5 is the godown receipt number 1. And Exhibit 5.1 is the signature of Tulika Maran, godown in charge. Thereafter, 8/5/2016, all the seized articles and contraband was taken out from the godown for production in the godown. I have received the godown receipt number 2. Exhibit 6 is the godown receipt number 2, wherein 6.1 is my signature on 8/5/2016. After production of the seized contrabands and articles, I have deposited of the seized articles and the contrabands to the godown. The godown in charge, Tulika Morang, received the articles and contrabands and acknowledged the same with the receipt number 3 dated 8/5/2016. Exhibit 7 is the godown receipt number 3 dated 8/5/2016, wherein signature of Tulika Morang in charge. Exhibit 8 is the godown receipt number 4. I have received samples S1 to S7 for sending the same to FSL Kailipara. I have received the samples. Exhibit 8.1 is the signature. Exhibit 32 is a test memo, wherein 32 is the 32.1 is my signature. Exhibit 33 is the receipt of office of the FSL Kahilipara. 33 for 33 2 documents prepared. One is for that is we have corrected, and Lanet PP pointed out that thing. Then in new paper book it has been corrected. So Exhibit 33 is the receipt of office of the FSL Kahilipara. Then Exhibit 33 also inventory. Exhibit 9 is the compliance report under Section 67 NDPS Act in connection with NCP case number so and so and so. Then Exhibit 33 is the inventory under Section 52A NDPS Act, wherein Exhibit 33 1 to 34 are my signatures. This only the inventory.
So what is that receipt of the office, that exhibit?
That is 30. They wrongly
232, no, there 233 has been written twice.
twice.
Will not make any difference if
No,
it's
ma'am.
properly identified.
Yes. So, we pointed out that thing and that has been correct. So on 8/5/2016, we produced the seized opium and morphine and documents and 4 accused persons to the judicial magistrate, Kamrup, Guwahati. Here, for a minute, I pause for a minute, Lordship. Exhibit 33 inventory. For inventory, there is specific law. Section 52 already for inventory, Lordship. So 52A subclause 2. If inventory prepared, then along with that, after search and seizure, all the contraband must have to deposit before the officer in charge of a police station or the officer in charge who is authorized under Section 53. Then, Lordship, what happened? The duty of the officer in charge and entrusted that he has to prepare the inventory with an application of maintaining all the things. 52A.
Yes, please.
52A, Lordship.
Yes.
Sir, my lord, 52 A1 is regarding the officials, and then this and 252 subclause 2. May I read, Lordship?
Yes, please.
Where any narcotic drugs, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53, the officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such detail relating to their description, quality, quantity, mode of packing, marks, numbers, and or such other identifying particulars of the narcotic drug, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, and controlled substances or conveyances in any proceedings under this act, and make an application to any magistrate for the purpose of certifying the correctness of the inventory so prepared, or taking in presence of such magistrate photograph of such drugs, substances, or conveyances, and certifying such photographs as to and or allowing to draw representative samples of such drugs or substances in the presence of such magistrate, and certifying correctness of any list of samples so drawn. Where an application is made under subsection 2, the magistrate shall, as soon as may be allowed the application, notwithstanding anything contained in Indian Evidence Act 1872 or the Code of Criminal Procedure 1973, every court trying an offense under this act shall treat the inventory, the photographs of narcotic drugs, psychotropic substances, controlled substances, or conveyances, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offense. So in our case, Exhibit 33 is the inventory only. There is no application regarding certifying the correctness of the inventory and taking photographs and with a permission to draw the samples in presence of the magistrate lords, which already decided by the apex court as well as division bench of our high court by his lordship. So it is delivered, the judgment delivered on 4th. Details discussion is also there. We're going to place the subsequently. Let me complete the deposition of the PW3 lord. So on 8/5/2016, I produced the seized opium and morphine and documents and 4 accused persons to the judicial magistrate Kamrup Guwahati. Exhibit 34 is the prayer for judicial custody of 4 accused persons in connection with NCB crime number so and so for recovery of opium and morphine. I requested prayer was made to the CGM Kamrup Guwahati to allow the seized vehicle bearing number so and so as the custodian. I sent all the 4 accused persons, namely so and so for medical examination. I have seized the articles along with the samples has been produced before the court. These are the material exhibit. Material exhibit 1, the dark brown color sticky materials marked as P1, which contains solutions of opium seized from possession of accused Saurabh Khan. It contains the signature of independent witnesses, 4 accused persons, and seizing officer. It also contains the signature of judicial magistrate Kamrup Guwahati on 8/5/2016. Material exhibit 2 is the dark brown color sticky material marked as P2, which contains 10.1 kg of opium seized from the possession of accused Saurabh Khan. It contains the signature of independent witnesses 4 accused persons and seizing officer. It also contains the signature of Judicial Magistrate Kamrup Guwahati on 8/5/2016. Material Exhibit 3 is the dark brown color sticky material marked as P3, which contains 10.7 kg of opium seized from the possession of accused Mohammad Mojibur Rahman.
Just a minute, just a minute. Simple about it, simple with the কথা 8/5 এটাতে এটা একেবারে লিখিত দিলে হয় নাকি যে আমার সার্চ টু কোর্টের বডি সার্চ করুন আর স্যাম্পলিং টু 8/5 কেতিয়া কৰিলে হলে 8/5 ঘটনা হৈছিল আপোনাৰ 6/5 খবৰ পাইছিলে 7/5 ইনসিডেন্ট হৈছিল 8/5 মেজিস্ট্ৰেটৰ টো আছিল স্যাম্পলিং কেতিয়া কৰিছে 8/5 কৰিছে স্যাম্পলিং 7/5 Simply PW J is 1 to S is 1 to S 7 simply at the place of incident into 52 meters sampling the signature to get here contraband to contraband to mark sample case police and looking at decrease. People present also before the registry along with the inventory. Inventory to signature policy of the sampling. I think that the sample has been certified and the inventory has been certified. Sample to the person. We have not much the contraband of the contraband of itself এটা তো বাড়ানো যদি লার্জ কোয়ান্টিটি হয় যদি স্যাম্পল রাখি স্টোর করে দেওয়ার পরে therefore a 52A has been going to primary evidence sampling was done when the entire contraband produced the magistrate sampling to Rakhar only for the purpose of sending it to the forensic, that's a different matter. At a whole picture of the possible packet to develop sampling. It only after forensic examination it was confirmed that it is not full. So what was said with the correct sample was sent to ensure that sampling has to be done. It is the name of yeah, sampling ministry from the sampling is what of the tasil provision. But okay, that is not in the central district provision. 52 evaluation into the pattern knowledge. And the question that it could be you have to do this for sure. You may need 52 evaluation. And this is what is the other to do what to decide. 52 evaluate the name, it should be. Basic material sound here. Yes, madam.
But I read all this part. These are the material exhibited before the court. Hold the case before going to the cross part lordship. Hold the case based on our argument based on 52A lordship. That has not been complied at all. Only kindly see the exhibit 33. Page to go. reading. Should I read all these things or Lordship, before that, Lordship would like to see this?
You go serially?
Then material exhibit, these are the regarding the material exhibit, Lordship. All the contraventions produced before the court, and from 1 to 18, Lordship, these are the material exhibits, Lordship. I read this. Material exhibit 3 is a dark brown color sticky material marked as P3, which contained 10.7 kg of opium.
This you can, same thing you may not.
Lordship, these are the same way, all the materials from which whatever recovered from the possession of the accused person as alleged, Lordship, that has been exhibited, Lordship, till Lordship page 24.
But entire seized goods were exhibited, is it?
Exhibited.
Because P marking P1, P2, P3, P4, P5 are the entire materials.
Yes,
Correct?
yes.
PRD seized materials,
Seized material.
contraband.
This is material.
P1, then you come to the next.
Yes.
After PC, after P7,
After P7,
then comes D.
D
are the
brown
duplicate
color.
samples.
Yes, duplicate sample.
Duplicate sample, because see the quantity. So for as P is there, entire quantity is there. D comes to 24 grams.
Yes, it's from exhibit 8, material exhibit 8.
So what is the purpose of 52A?
That is why I will explain, Lord.
No, what is the purpose?
Purpose of exhibit, purpose of 52A. All the material he must have to, if the officer collects all the samples at the spot, that sample he has to deposit before the officer in charge. Then it was the duty of the officer in charge to prepare an inventory, and all the samples and all the contrabands again produced before the magistrate, and with application to certify the correctness of the inventory and the photograph. Thereafter, with a permission to draw again the sample before the magistrate.
Why is it necessary?
It is necessary to constitute as primary evidence.
Why?
As the Act says so.
No, why? Primary evidence. Why the sample and the inventory will be primary evidence? When?
Authenticity of the seized contraband.
When will it be necessary? When the contrabands are destroyed.
No, Lordship, that is not the law. It is necessary, Lordship, if even produced before the court.
Yes.
Then only it will not amount to this comply the provision of section 52A.
52. Let us read 52A. What is the intent of the legislation?
Before we also go to that one point, what I remind of.
Yes.
So I am casually, my specific casual mind.
Right.
Basic question, madam, initial that is a false implication was there, madam, because these people, whether the 4 persons were working, so that it brought to the 52A is to point of that. Because authenticity and whether it was really done or not, madam, or some manipulation was there, madam. For this only 52A is required. No.
Madam, 52A surplus 2.
Yes, please.
Where any narcotic drug, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53, the officer referred in subsection 1 shall prepare an inventory. It's mandatory. Of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such detail relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of narcotic drugs, psychotropic substances, controlled substances, or conveniences, or the packing in which they are packed, country of origin, and other particulars, as the officer referred to in subsection 1, may consider the relevant to identity of the narcotic drugs, psychotropic substances, controlled substances, or conveniences in any proceeding under this act and make an application to any magistrate for the purpose of certifying the correctness of the inventory so prepared, taking in presence of such magistrate photographs of such drugs, substances, or conveniences, and certifying the such photographs as true, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. Where an application is made under subsection 2, the magistrate shall, as soon as may be, allow the application notwithstanding anything contained in Indian Evidence Act or criminal procedure. Every court trying an offense under this act shall treat the inventory, the photograph of narcotic drugs, psychotropic substances, controlled substances, or conveniences, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offense.
Madam, what is the heading of this section?
Heading of this section, disposal of the narcotic drugs and psychotropic,
Disposal.
but
Disposal.
sorry, disposal of seized narcotic drugs and psychotropic
So
substances,
if
that is correct.
If it is this, well, can you listen to the
Lord,
quote? We are discussing.
Lord.
We have not come to a final finding.
Lord.
See, if it's disposed of, the commodity is not there. What would remain to be proved? So this has been done that in case you want to dispose it of, this is the procedure you have to maintain, and those samples, those photographs, those inventories are certified will be treated as primary evidence. But here is a case where it was not disposed of.
But
we have to
Yeah.
to make out a case, build up an argument that 52A, the case which you are trying to build, whether it will really help you. Because here is a case where the seized materials have not been disposed of. It was rather entire materials are proved before this court and produced
if,
in the trial.
if produced, that not constitute this that they are the primary evidence because they have not prepared the inventory. Inventory must have to prepare as to produce as to considered as a primary evidence, Lord.
What would be considered? What is the primary evidence, madam? Primary evidence is the contraband. It is not necessary in all cases the contraband is required to be produced. At times there may be thousands of kilos of ganja not be able to produce, and you want to destroy it. But if you destroy, how will you prove the case? So this is given as a measure. How do you treat this as a primary evidence if the contraband seized is not there? Here is a case, it was not even disposed of. You try to examine your case from that angle.
Yes, of course, Lord.
When these are dangerous substances, you want to dispose these of, then what do you do?
Lordship, in judgment passed by this honorable court by his lordship, I would like to place that one to clear this point, lordship. This case has been discussed in fair discussion regarding this non-compliance of, though inventory was there in this case. It is start from page 42. No, 45. Para 45.
Page,
Page lordship 47. It starts from there, lordship. And all the judgments regarding apex court judgments cited in this case till up to the latest judgment 2024 issue Muhammad Khalid.
para 47.
It start from 40. Page 45, para 45. Start from para 45.
The standing order.
It's including standing order.
No, start, line is the standing order 189.
Yes, standing order along with the section section mentioned in the paragraph 45.
Please read.
Yes, standing order. This is regarding your lordship. This is regarding some standing order 1/89, 13/6/1989 was issued by the central government in exercise of the power conferred by Section 1 of Section 52A of NDPS Act, determining the narcotic drugs and psychotropic substances which were to be disposed of and laying down the manner in which such specified narcotic drugs and psychotropic substances were to be disposed of after seizure. Ganja was included in the list of specified narcotic drugs in the standing order 1/89. The expression after following the procedure herein after specified appearing in section 52A1 is the significance. From the combined reading of subsection 1 and subsection 2, it becomes evident that after seizure of the specified contraband substance, such specified contraband substance are to be disposed of only after following the procedure thereafter specified. The procedure to be followed before disposal of the specified contraband is mentioned in subsection 2 of section 52. In other words, the disposal of specified contraband substances is to be proceeded by preparation of an inventory of such specified contraband substances by the empowered officer containing the details mentioned in therein, making of an application by the empowered officer to a magistrate for the purpose of certifying the correctness of the inventories of prepared, or by taking the presence of magistrate photographs of such contraband and conveyances and such photographs of by the magistrate as to allowing to draw representative sample of such seized samples in presence of magistrate and certifying the correct samples. Turning to the evidence material on record, it is evident from the Panstama prepared on 5/12/2014, the first information report read with Appendix A thereto submitted in compliance of Section 57 of NDPS Act 8/12/2014, and the complaint filed under Section so of the NDPS Act, and thereafter seizing 29 numbers of H3PE packages suspected to have contain cannabis weighing so as per women's seat in the office premises of the custom office situated at Christian Basti, Guwahati in the early morning hours. An inventory of goods seized was prepared at the same place. After preparing the inventory goods seized, sample in duplicate weighing samples were drawn from 29 packets suspected to have contained cannabis, and those samples were seized in presence of accused persons and in presence of witnesses for sending those samples to the FSL or DFSL for chemical examination. The prosecution witnesses had all testified about the preparation of inventory of goods in premises of custom office. The prosecution witnesses had all testified that samples were drawn in duplicate from each of the 29 numbers of HDPE packages containing the suspected ganja in the premises of the custom office Guwahati on 5/12/2014. After seizure of 29 HDPE packages containing suspected cannabis, preparation of inventory of goods seized, drawal of sample for those 29 of HDPE packages and arrest of 2 accused persons. Those were produced before the court of learned Chief Judicial Magistrate Kamrup Guwahati. An application was also submitted by the seizing officer and arresting officer P.K. Deka. The contents of application are already extracted from the paragraph number 7. These are the contention. Then should I read this one? The document including the seizure list prepared and the seized article and samples drawn may kindly be seen. In view of the above, it is respectfully prayed that Your Honor may be pleased to pass an order remanding the aforesaid accused persons to judicial custody and also allow custody of the seized article. Both the 6-wheeler closed truck container truck bearing number so all the seized articles still decision of the case. To pass such an or such order as Your Honor may deem fit and proper. It is also prayed that the inventory goods seized along with the other documents and the samples drawn along with the seized article may please be seen. On 6/12/2014, the learned Chief Judicial Magistrate Kamrup Metro passed the following order. Seizing officer P.K. Deka has produced inventory of the goods seized 29 packet sample cash amount and inventory of goods seized 29 of sample cash amount and seized ganjas are seen. Inventory be kept with so articles are to be returned to the SO. Accused persons Sri Binod Kumar are produced before the court under arrest by Customs Office in connection with the above noted on being as accused persons have stated that their family members will engage advocate to defend them. Considering the nature of the case, accused persons are remanded to Hajot till Superintendent of Central Jail is directed to produce the accused persons on the next day before the honorable.
Those you can skip. Factual part you can skip.
Factual part, whole the discussion is there, Lordship, regarding the presence of if produced the contraband. In that case also, it is not admissible. That is decided by the apex court also.
If you kindly show this. Yes.
My lord, his lordship referred Mohanlal judgment here. It is mentioned in page number 52 from Mohanlal lordship paragraph 12. It has been discussed regarding this regarding the section 52 whether it is regarding to disposal or it constitutes as a primary evidence or not if samples not drawn before the magistrate. It is mentioned in page number 52. My lord, in this judgment, in page number 59, one apex court judgment relied upon lordship, that is Yusuf Asif lordship is that is discussed, and in the page number 61, there is 61 paragraph number 16.
61.
61 paragraph number 6, it is inside the judgment lordship, it is the apex court judgment Yusuf Asif lordship.
Yes.
It is stated that in paragraph number 16, in absence of any material on record to establish that lordship got it,
Yes, yes.
samples of the seized contraband were drawn in presence of magistrate, and that the inventory of the seized contraband was duly certified by the magistrate. It is apparent that the state contraband and samples drawn therefrom would not be a valid piece of primary evidence in trial. Once there is no primary evidence available, the trial court as a whole stands vitiated. This is issue as if we have the copy.
Sampling was done. So it is a little bit of question. But question
The entire commodity is produced. Primary evidence of what happened.
there is a violation of statutory sampling is done to samples. Number like in this scheme of independence, sampling and producing of other apart from the state doesn't question is not done. The sampling is still genuine evidence. The sampling was done into primary evidence and
Mr. Kyle, 52A, kindly have 52A. Is primarily on the basis of how do you dispose of the seized commodities. And some things have been laid down. And in subsection 2, the aspect of sampling has also come.
Yep.
This is required, and what is required to be proved in the primary evidence is the list of the not only list of the even the list of samples,
Yes, sir.
not the samples.
Yeah.
List of samples.
Okay.
So this is one part. So far as the forensic test is required, suppose you seize one bag of flour. Somebody says it's NDPS, but it's actually flour. It needs to be tested.
Yes.
Samples are needed to be sent to the FSL. So that sampling and that testing is done under which provision?
But if
Suppose the seized quantity is 20 gram. There may not be record or maybe 50 gram, may not be requirement of any destruction.
That is provided in notifications, each drug, how much sample is to be collected. Notification is,
No, notification, and you need to be tested.
Yes.
And the requirement of destruction may not be there in all cases.
Yes,
Where the quantity is so small that it is not causing any difficulty. And you can prove, even in this case, the entire contraband was proved as primary evidence, everything, P1, P2, P3, P6. It was in the trial. So, but the other aspect, that these seized materials were contraband coming within the definition of narcotic drugs and psychotropic substance, that is done under which provision? The Seizure we have seen, Seizure does not say anything.
List of. List of.
That it has to be sent for FSL.
FSL.
How is it to be sent? See, in NDPS, without there being a test of FSL, it cannot be.
it cannot.
Because the entire, the basis of the allegation is you are carrying NDPS. Who will call it an NDPS? It's only after a test. So only by some touching or by seeing one, nobody can say it's a NDPS
There are
thing.
two stages, at the time of seizure, they tested by fixed kit.
No, that will not be a proof which is recognized by law.
but
That is your satisfaction to seize it.
Yes, but what happened? Simply yesterday, one point has been arose before court, where the complaint was filed without taxing a vessel. Now there are divergent view of even promoter. Now the matter has been sent to the full. Whether the complaint can be filed without FSL. During that judgment, what it was observed by the court. The purpose of this thing is to the report will be admissible as an evidence in the trial. Not at that if it is detected through fiction kit, then it is sufficient. Now the question is
No, we are not even going to that issue.
No.
We think that even without an FSL, the complaint is not a final proof.
Just
You need to prove it by FSL.
yes, doctor. That is to be the evidence.
Yes.
So otherwise, it will not be
Yes,
admissible.
yes.
Lordship, regarding lordship question, if quite some time to procedural
Just
lordship.
a minute, just a minute.
Where are the provisions for sampling?
Mhm, so I see.
Only 52. Is there any other provision?
But 52 does not say that you are did sampling, then you present it to the FSL. This is only for the purpose of retaining it when you are destroying the entire thing. The kindness, আপনার একটু question হবো না যে বস্তুই না ছিল। Ministry has certified, inventory আছে, list of sample আছে, certified person treated the primary evidence.
Okay.
Which move
Wait.
takes place and then in this things the question is not answered.
না 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 ঠিক একদম আপনার উদাহরণ দিচ্ছে এইটা
What was the purpose of sampling in 52? When list of samples.
আপনি একটু 46,000 Road judgment, 46.
Yes.
52 was introduced in 1980.
59.
There was a notification was being followed by all the. Then after amendment. There, 1 of 89. Yes, sir. It is not a big. Type. The purpose of the statement of checks and reasons for 1989 amendment. Property is that for If we cut to vessel, there is whether there is any provision that I have checked your notification, there are not some notifications there. Notification on of 89 describe how much what is the quantity to be drawn for which drug, that is mentioned in the for 89 notice, what was the prescription that I have if there in 2022 all notice were repealed and the phrase guideline was I placed on other case, place again. That prescribed
Lordship. Exactly. Lord.
yes, Lord. Because at the time of seizure, two samples are made. One is
Primary
original
and
and
secondary.
one sample is primary. We have to, but the agency were following the notification of 1 of 89. Not sent, sent to the
My lord, kindly go to the text for judgment Mohanlal once again, Lord. It is start from seizure and sampling. I think I can do a little bit to some extent, Lordship satisfied to that regard. If Lordship, paragraph number 12, it starts regarding search and sampling. Page Lordship 407. Mohanlal, I think I have placed. Paragraph Lordship 12, page number 407. Lordship, it's regarding seizure and sampling. Regarding this standing order 1/89 also discussed. Once again, if we go 12, 13, then 14 is regarding the section and 15. I think Lordship queries may be clear. Yes. May I read, Lordship? That 52A, but why it is necessary, that is also discussed in there. Section 52A1 of NDPS Act 1985 empowers the central government to prescribe by notification the procedure to be followed for seizure, storage, and disposal of drugs and psychotropic substances. The central government has, in exercise of that power, issued Standing Order 1 of 89, which prescribes the procedure to be followed while conducting the seizure of the contraband. Two subsequent standing orders one dated 10/5/2007 and other dated 16/1/2015 deal with disposal and destruction of seized contraband and do not alter or add to the earlier standing order that prescribes the procedure for conducting seizure. Para number 2.2 of standing order 1/89 states that sample must be taken for the seized contraband on the spot at the time of recovery itself. If it reaches, this is regarding recovery at the spot. Para 13, most of the states, however, claims that no samples are drawn at the time of seizure. Director of Revenue Intelligence is by far the only agency which claims that samples are drawn at the time of seizure, while Narcotics Control Bureau asserts that it does not do so. There is thus no informed practice or in para 19, hold a discussion regarding 52A, how today 15 is also there, but regarding certification and all, thereafter in para 19, it is clear, Lordship. May I read, Lordship? Mr. Sina Learned amicus curiae argues that if an amendment of the Act stipulating that the samples be taken at the time of seizure is not possible, at least that ought to be done is to make it obligatory for the officer conducting the seizure to apply to the magistrate for drawing of samples and certification, except without any loss of time. The officer conducting the seizure is also obliged to report the act of seizure and the making of the application to the superior officer in writing, so that there is a certain amount of accountability in the entire exercise, which as at present gets neglected for a variety of reasons. There is, in our opinion, no manner of doubt that the seizure of the contraband must be followed by an application for drawings of samples and certification as contemplated under the Act. There is equally no doubt the process of making any such application and resultant sampling and certification cannot be left to the whims of the officers concerned. The scheme of the Act in general and Section 52A in particular does not brook any delay in the matter making of an application and drawing of samples and certification, while we see no room for prescribing or reading a time frame into provisions. We are of the view that an application for sampling and certification ought to be made without undue delay, and the magistrate on receipt of any such application will be expected to attend the application and do needful within reasonable period and without any undue delay or procrastinations as is mandated by subsection 3 of section 52A supra. We hope and trust that high courts will keep a close watch on the performance of the magistrate in this regard and throw the magistrate on the agencies that are dealing with the menace of drugs, which has taken alarming dimension in this country, particularly because of the ineffective and lackadaisical enforcement of laws and procedures and cavalier manner in which the agencies and at the times of majesties in this country addresses the problem of such serious dimensions. Then Lordship in Asif Yusuf, it is clear in paragraph number 12. And that has been summarized, this summarized Lordship in paragraph number in Mohanlal. In this case, in this judgment, Lordship, regarding disposal also in paragraph number 27 in Mohanlal. 27, 28 is relevant. Section 52A amended provides for disposal of this contraband in the manner stipulated by the government under subsection 1 of that section. Notification dated 16/1/2015 in subsections of earlier notification 10/5/2007 not only stipulates that all drugs and psychotropic substances have to be disposed of, but also identifies the officers who shall initiate actions for disposal and the procedure to be followed for such disposal. Para 4 of the notification inter alia provides that the officer in charge of the police station shall, within 30 days from the date of receipt of the chemical analysis report of drugs, psychotropic substances, and controlled substances, apply to any magistrate under section 52A surplus 2 in terms of annexure to said notifications. Subpara 2 of para 4 provides that the magistrate allows the application under subsection 3 of section 52A, the officer mentioned in subpara 1 of para 4 shall preserve the certified inventory photograph samples which lordship queries. The samples drawn in presence of the magistrate as primary evidence for the case and submit details of these items to chairman of the drugs disposal committee for a decision by the committee on the question of disposal. The officer shall also send a copy, the details along with the item seized to the officer in charge of the godown. Para 5 of the notification provides for constitution of the drugs disposal committee, while para 6 specifies the functions which the committee shall perform. In para 7, the notification provides for procedure to be followed with regard to the disposal of the seized item, while para 8 stipulates the quantity and or value up to which the drugs disposal committee can order disposal of the seized item in terms of the proviso to para 8. If the consignment are larger in quantity or higher value than those indicated in table, the drugs disposal committee is required to send its recommendation to the head of the department, who shall then order their disposal by the higher level. The drugs disposal committee is specially constituted for that purpose. Para number 9 prescribed mode of disposal of the drugs, while para 10 requires the committee to intimate to the head of the department the program of destruction and vest the head of the department with the power to conduct a surprise checklist or depute an officer to conduct such checks on destruction operation. Para 11 deals with certificate of destruction, while para 12 and 13 deal with details of sale to enter into the godown, registered and communicate to be sent to the Narcotic Control Bureau. Then there are two other aspects that needs to be noted in this stage. The first is notification dated 16/1/2015 does not in terms of supersede standing order 1/89 insofar as the said standing order also prescribed the procedure to be followed for disposal of narcotic drugs and psychotropics and controlled substances and conveyances specified overriding the earlier standing order would have avoided a certain amount of confusion which is evident on the account of stimulation simultaneously presence of standing order 1/89 and notification dated 16/1/2015. For instance, in para 1 standing order 1/89 only certain narcotic drugs and psychotic substances enumerated therein could be disposed of, while notification 16/1/2015 provides for disposal of all narcotic drugs and psychotic substances, psychotropic and controlled substances are conveyed. Yes, guidelines are there. 3.1. Then guideline. Then Lordship 31 in paragraph number 31, holder judgment summed up. It is summed up, Lordship, how to maintain these things. No sooner the seizure of any 31.1, no sooner the seizure of any narcotic drug or psychotropic substances or controlled substances or conveyances is effected, the same shall be forwarded to the officer in charge, to the nearest police station, or to the officer empowered under section 53 of the Act. The officer concerned shall then approach the magistrate with an application under section 52A subclause 2 of the Act, which shall allow by the magistrate as soon as by required under section 3 of the section 52A as discussed by us in the body of this judgment under heading seizure and sampling. The sampling shall be done under the supervision of magistrate as discussed in para number 15 to 19. So, Lordship, in our case also, in the NDPS case, Lordship, 50, though it is heading that it is 52A is heading that regarding the disposal, at the time of the, because of disposal, the inventory should be prepared. But as per this Lordship interpretation, just after the search and seizure, they must have to deposit it to the officer in charge or the officer empowered under section 53. He shall prepare the inventory, not for the purpose of disposal. That is discussed in earlier paragraph in this judgment, Lord. And that is, and to subclause 4 of section 52A, it is clear to constitute as primary evidence, Lord. Until and unto this list of samples certified by the magistrate, until and unless the list of sample certified by the magistrate that it is true or in presence of me it has been collected, until and unless that certification is not there, that should not be considered as primary evidence, even if placed before the trial court during the trial. And that is discussed in Yusuf and Asif by the Honorable Apex Court. That is, I have placed that. It is a mandate of the that is discussed in this case, Lord. Yusuf and Asif. In this case, in the case which his lordship decided in 4/10/2024, that is in that case also hold the contraband produced before the court and materially exhibited 1 to 29 packages. Even after that, that has been discussed, Lordship. That has been discussed and disposed of as per non-compliance of this section 52A. That is there, Lordship. But before that, Lordship, it is in paragraph 12 of Yusuf and Asif 2023-7 SCC, Lordship. It is clear we made question regarding section 52A, Lordship. It- I think that is not there, but even after that, Lordship, we put the main ground, Lordship, though they have, this is the mandatory section, Lordship. This mandatory section has been violated on the part of something. If it is so, Lordship, recent judgment of the Honorable Apex Court, then all the things are waste paper, Lord. In Muhammad Khalid judgment is there. Yusuf Asif, paragraph number 12. It start from 12, Lord. May I read, Lord? 52. Yes. Lordship. Paragraph. It starts from 12. A simple reading of aforesaid provisions, as also stated earlier, reveals that when any contraband narcotic substances is seized and forwarded to the police and to the officers so mentioned under section 53, the officers so referred in subsection 1 shall prepare its inventory with details and the description of the seized substance like quality, quantity, mode of packing and numbering and identifying marks, and then make an application to the magistrate for purpose of certifying its correctness and for allowing to draw representative samples such substances in the presence of magistrate and to certify the correctness of list of samples so drawn. Notwithstanding the defense set up from the side of the respondent in an instant case, no evidence has been brought on record to the effect that the procedure prescribed under subsection 234 of section 52A NDPS Act was followed while making the seizure and drawing samples such as preparing the inventory and getting it certified by the magistrate. No evidence has been brought on record. The samples were drawn in presence of magistrate and a list of samples were drawn were certified by the magistrate. The mere fact that samples were drawn in presence of gazetted officer is not sufficient compliance the mandate of section subsection 2 of section 52A of NDPS Act. It is an admitted position on the record that sample from the seized substance were drawn by the police officer in presence of gazetted officer and not in presence of magistrate. There is no material to record to prove that the magistrate has certified the inventory substances seized or of the list of samples so drawn. In Mohanlal's case, the apex court, while dealing with the section 52A of NDPS Act, clearly laid down that it is manifest from the said provisions that upon seizure of the contraband, it has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under section 52 who is obliged to prepare an inventory of the seized contraband, then to make an application to the magistrate for the purpose of getting its correctness certified. It has been further laid down that the samples drawn in presence of the magistrate and a list thereof on being certified alone would constitute primary evidence for the purpose of the trial. In absence of any material on record to establish the samples of the seized contraband were drawn in presence of magistrate and the inventory of the seized contraband was duly certified by the magistrate, it is apparent that the said seized contraband and samples drawn therefrom would not be a valid piece of primary evidence in the trial. Once there is no primary evidence available, the trial as a whole stands vicious. Accordingly, we are opinion of the failure of concerned authority, primary evidence vicious the conviction. And as such, in our opinion, the conviction and status. Lordship, what happened in this case, what my understanding goes, Lordship, whenever the samples collected and seized material bring to the office, it is the duty of the seizing officer to place before the officer empowered in their department, officer empowered under section 53. And just after that, it is the primary duty of that officer to prepare the inventory and place before the magistrate for certification and for sampling. That samples must have to be considered as a primary evidence. Though it is produced before on later part, if it is produced before the magistrate, that cannot be considered as a primary evidence as per the Act. And that is what in
Ms. Nargis, whether samples constitute primary evidence or list of samples,
list of samples,
there is a
which
difference.
are application.
No. Our query is what constitute primary evidence in when the original contraband is destroyed? What is the statutory provision?
Statutory provision as per the
Clause 4 says that inventory, photographs and
list of
list of samples. It does not speaks about samples.
samples. List
So-
of sample when prepared, Lordship, when
Our query is, what is the purpose of having provision for drawing samples in 52A when samples itself do not constitute primary evidence? Provision is that list of samples are sufficient to constitute primary evidence. Then why samples are to be drawn? What is the purpose?
That is-
Why 52A provides for drawing of samples?
uh,
Because in absence, you have understood our query. In absence of original, in this case, the original contraband was not destroyed. But the Mohanlal judgment says that as soon as the contraband is seized,
At the earliest, application has to be filed within 30 days as per the subsequent notifications. So if the original contraband is destroyed, then the primary evidence, the list of samples, inventory, and photograph will be substituted as primary evidence. As per section sub
Four.
4, it does not mentions about samples. Then what was the necessity of having provisions for drawing samples in 52A?
My lord, it is clear,
What is to be done with that sample?
lordship. My lord, it is clear, your lordship judgment in paragraph number 7. It
What?
is clear, lordship. In that case, lordship discussed that holder contrabands and sample produced and materially exhibited before the court during the trial. Then thereafter, it is discussed in paragraph number 70. May I read that paragraph?
No, that is
That-
not our
that-
query.
I understood, lordship, regarding the sample if drawn, then list the necessity of primary evidence is not required. If
No. The query is whether samples from contraband you draw two samples, original and duplicate, marked as S and D. Though whether those samples can also be used as primary evidence.
without certifying by the magistrate, it cannot be considered as a primary evidence.
Or is it required to preserve sample to be used as primary evidence, or whether list is enough? Had there been
List,
no samples,
list along with the certification, Lord. List along with the certification is required to establish a case under this act.
Oh.
That is cleared in this paragraph, Lord. Paragraph 70 of this Honorable Court Division Bench, Lord.
okay, suppose original sample, you have drawn two samples, S and D. S has been sent to forensic laboratory. D has been misplaced, destroyed during trial. You don't have samples, any samples remaining, but you have list of samples which was certified by the magistrate.
That will be enough to establish a case under this act,
Okay, that was my query.
Lord. Certification আৰু certificate লগতে নালাগে। When it is produced before the court and in presence of magistrate, it is it draws, then it certified by the magistrate, then only that it amounts to this satisfaction of this section, Lordship, this as a primary evidence, Lord. And in that case, the presence of the samples is not required before the court. And if without doing that, if produced before the court, that will not constitute as a primary evidence.
Suppose original contraband was not destroyed.
In that case also, because section,
Whether original contraband will not constitute as because it will always remain primary evidence.
no, as section provides their lordship, just after seizure, it should be placed before the officer in charge or the officer empowered under section 53. He prepared an inventory and draw the sample and list of samples with the photograph. That should be considered as a primary evidence. Otherwise, if produced without following the provisions, then that will not constitute as a primary evidence. What subsection 4 says, Lord. Nobody helps me. It was an application. Shall prepare, then make this application. No, it is your color. My lord,
If you raise any in your defense that P1 to P7 are not the materials that were sealed.
before answering that question, Lordship, kindly go through one latest judgment of Honorable Apex Court, Lordship. That is Muhammad Khalid. What query made by this court, Lordship? Yeah, Muhammad Khalid. Paragraph 19, 20, 22, and 26. 19. Lordship got it. Seizure officer also stated that he collected 3 samples of ganja at the spot and handed over 1 sample to accused. If this was true, apparently only 2 samples packet remained for being sent to FSL. Contrary to the evidence, PW15 stated that 3 samples of ganja were taken by so-and-so who handed over the same to him. Thereafter, these samples were forwarded to the FSL through ACP and FSL report was received. When PW5 appeared for deposition, he produced the Mandamal ganja in the court, and it was seen that the same was packed in 7 new bags as against the 3 bags referred to in Seizure memo. Neither any proceedings were conducted nor any memo was prepared by the police officer for repacking the seized ganja bundles in new packaging. The 2 independent funds witnesses so associated the recovery of proceedings were not examined in evidence, and no explanation was given by prosecution as to why they were not being examined. 22. Sub-Inspector who prepared 3 samples of ganja who prepared 3 samples of ganja as per the testimony of PW5 was not examined in evidence. In addition thereto, the prosecution neither examined any witness nor produced any document to satisfy the court regarding safekeeping of the samples right from the time of the seizure till the same reached the FSL. The official who collected the samples from the police station and carried to the FSL was not examined at the trial. From the quoted portion of the evidence of the seizure officer, Inspector Swanson, it is clear as daylight that he handed over one of the 3 samples to the accused. The witnesses also admitted that he did not mention about stealing of samples in the Panchnama. Then come to paragraph number 26. Admittedly, no proceeding under section 52A of NDPS Act were taken by investigating officer PW5 for preparing an inventory and obtaining samples in presence of jurisdictional magistrate. In view of the matter, the FSL report is nothing but a waste paper and cannot be read as evidence. In the accused ATN were not arrested at the spot. So that is decided by the Honorable Apex Court latest. in latest judgment, Lordship. If not followed this provision, just immediate, just after seizure and depositing by the to the officer entrusted as empowered under 53, then the FSL report nothing but a waste paper that has been decided. Whether we made question in the trial court or not, that is a separate part. But in our case, Lordship, this provision not followed. Regarding 52A, we have made the question during the time. And that is admitted by that inventory, one inventory prepared, no application made, no samples drawn at the before the measure.
For the purpose of 52A and sampling for the purpose of getting it tested by the FSL, is it the only provision or?
No, Lordship, notification on 59 paragraph 3 has been
What is there?
put to law.
In that case, you have to read the 22 rules also.
Yes.
22
This
rules.
says the
Yes.
seizing officer, the central government department, namely Custom, Central Excise, Central Bureau, Narcotic Control Bureau, Director of Revenue Intelligence, etc., should dispatch samples of the seized drugs to one of the laboratories, the Central Revenue Control Laboratory nearest to their office, depending upon the availability of the testing facility. Other central agencies like BSF, CPI, and the Central Police Organization may send such samples to the Director, Central Forensic Science Laboratory. All state enforcement agencies may send samples of these drugs to the Director, Deputy Director, and Director of their respective state forensic science.
This is the aspect of sending.
Yes.
How is sampling to be done?
Paragraph 2 of that notification. All drugs shall be properly classified carefully, weighted and sampled on the spot of seizure. All the packets containers shall be serially numbered and in lots for sampling. Samples from narcotic drugs are substance. These shall be drawn on the spot of recovery, duplicate, in the presence of such witnesses, puncher, and persons from whose possession the drugs were recovered, and mentioned to this effect should be invariably be bona fide in the panchanamas on the spot.
Can you have a look at the notification?
I have copies.
sent-
I'm
Yes,
Interesting point of view. Incidentally, it's Sampurna, 1989 amendment. এই notification 1 of 89 হয় এইখানেও notification এখনো contemplate করবে সেন্ট্রাল গভর্নমেন্ট বাই notification আৰু গভৰ্ণমেণ্টত কৈছে কি সেই notification এইটো তুমি ফলো নকৰে বেলেগ লিক কৰিব you can notification may not be proper but if that notification is apart from being a notification under 52A1 is also covering other aspects.
Paragraph 2.1 speak about how to sample to be drawn.
Notification.
I don't know how to do it. If you mention the common only this,
Yep, yes.
only this. এখানে আমি সাবও
Yeah,
করেছি
আপনি যখন question discuss
এইট সার্ভেন্ট কিভাবে বেশি সেট করেছি না এটা কারেক্ট ইট ইজ অনলি আফটার 52 ওয়ান অর নোটে করেছি
has to be.
রেড এলং উইথ
I can be careful for the
Mr. Kyle, 1 of 89 in its the prelude, it says it has been published in exercise of powers under 52A1.
Correct.
So there is no ambiguity that it is a notification under that provision only.
Correct.
We are asking whether there is any other provision. See, this notification has been read down and later on substituted. So is there any other provision or any other thing in the act itself? How do you draw samples? Before whom? How do you send it to the FSL? Irrespective of what 52A2 is there. 52A2 is still we are reiterating that is mainly for the purpose when you dispose of the seized articles.
Seized.
If you do not dispose of, then also you are required to make a test. 89 of 1, 1 of 89 was essentially under, was a notification under 52A1.
Yes, sir. Yes, for that amendment.
So obviously, Honorable Supreme Court has said that you cannot have something in a notification which is contrary to the
Yes.
statutory provision. Okay, we'll come back.
Not-
But this is one interesting. Mr. Chaudhary's input would be required.
That might have.
Now, apart from the factual part, something has to be clarified on the legal aspect.
I'm sorry for that, you know. Tomorrow, Procedural, Honorable Chief Justice.
My lord, can we part this matter on
Part is bit difficult.
next week on Tuesday?
We'll not say part we may fix it next week, next Tuesday, because this bench is not very certain. We can try it. Well, let us come back at 2.
Lord,
You'll be
Lord,
there, Malad,
Lord,
that's why you'll
let-
just-
let
We,
me
we
check.
have a meeting because we have prize.
Mal-
Lord.
This notification, Mr. Kyle, this one of 89 is it has been taken out in exercise of powers under 52A1.
Yes.
So it is not for any other purpose, but for the powers, but under the powers vested under 52A1.
Yes.
And so 52A2 will definitely follow this.
Yes.
So we are only on the aspect of the sampling so far as FSL test is required. And that becomes of vital importance.
Yes.
Because it is at that point, most of the cases are there. How
Yes.
did you take the sample? How was it sealed?
Yes. Subsequently, after Mohanlal case, if this notification was repealed in 2022.
No, that's a different aspect. But Mohanlal in express terms has said that this is this notification appears to be in conflict with the second part of the 52A2.
Two.
So notification cannot bypass or be in conflict
is
with the
correct.
statute.
But-
But we are on the aspect of the, again we are repeating, 52A is mainly for disposal and the procedure which you are to take before disposing. And what are the requirement, why the requirement of disposal comes? Because of the certain factors. Storage may be a problem, theft may be a problem, precarious conditions may be a problem. In fact, in one of the cases, reports were called for from all the states regarding this shortage of space, the storage space.
It was taken care of in subsequent judgment. Also.
Yes. So those were a few of the relevant consideration that if you need to dispose of the goods, the contraband, then how do you proceed in the trial? If tomorrow the situation comes that where is the contraband?
Yes.
You can neither store, neither dispose of, then what will happen? So
So then-
59, 50, this has been incorporated. If you dispose of, maintain this procedure, and this will be primary evidence under subsection
My
4.
lordship, this was the purpose of amending NDPS Act in 1988.
1989,
Yes.
yes, correct. Now, whether that part of sampling and requirement of the sampling being done before a magistrate
Yes.
would also be for the purpose of sending it for the FSL examination. And at the same time, one may very well argue that how do you ensure that the sampling was done properly in a manner recognized by law, that it was done, the same thing was sent for test.
Then lordship, circumstances when
The moment the magistrate's role comes in, sanctity comes in.
yes,
So it's
lordship,
very,
that is correct.
it's natural for them to argue that yes, same procedure has to be followed. Because other than this, at least we have not found anything in the statute regarding how do you collect sample. Is there anything, please?
It
kindly
is
show.
not.
Madam,
Except
we left some
What
paragraph.
about the rules?
Rules also lordship doesn't speak about.
What about the latest rules of 2022? While one of 89 has been repealed, rules have been framed. 2022.
Yes.
As a copy of it.
Santan, it's the dialogue. It's sort of for
You.
আধা ঘন্টা পিছত বন্ধ কৰি দিব এতিয়া দি দিম
We have the extra copies for 22. Madam, before going to the 2020 rule, kindly look first Mohanlal judgment once again
Yes.
in paragraph number 16 and 17, Lord.
Mohanlal.
16, 17 and 18.
Mohanlal.
Yes. Two 16, Lord, 2016, yes.
Yes. Paragraph.
Paragraph 16, 17 and 18, Lord. We left out at that time.
Page.
Page number 409.
Yes, yes.
Yes. May I read, Lord? Subsection 3, para 16, subsection 3 of section 52A requires that magistrate shall, as soon as may be allowed the application. This implies that no sooner the seizure is effected, the contraband forwarded to the officer in charge of the police station or the officer empowered. The officer concerned is in law duty bound to approach the magistrate for the purposes mentioned above, including grant of permission to draw representative sample in his presence, which samples will then be enlisted and correctness of the list of samples so drawn certified by the magistrate. In other words, the process of drawing of sample has to be in presence and under the supervision of magistrate, and the entire exercise has to be certified by him to be correct. The question of drawing of sample at the time of seizure more often than not takes place in absence of magistrate does not in the above scheme of the things arise. This is so especially when, according to section 52A4 of the Act, samples drawn and certified by magistrate in compliance with the subsection so and so above constitute primary evidence for the purpose of the trial. Suffice it to say that there is no provision in the Act that mandates taking of samples at the time of seizure. That is perhaps why none of the states claim to be taking samples at the time of seizure. Be that as it may, conflict between the statutory provisions governing taking of sample and standing order issued by the central government is evident when two are placed in juxtaposition. There is no gainsay that such a conflict shall have to be resolved in favor of the statute on first principles of interpretation, but continuation of statutory notification in its present form is bound to create confusion in the minds of the authorities concerned instead
That is
helping.
why we had said to Mr. Kayat that it has been expressly been.
It is not in the
It
act,
hasn't
Lord.
said a 52A, this one of 89 cannot withstand 52A. That has been said. It's a different matter that 2022 it was repealed. But after Mohanlal, it is not existing
Lordship.
legally if you go.
Lordship.
But we are slightly on a different footing.
But Lordship, it is not in the act. Here it is clear that it is not in the act regarding taking of sample and all. It is mentioned in the paragraph number 17. Lord. And whatever collected by the inventory, that must have to prove in during the trial.
of first line to key meaning. What is the meaning of the first sentence of 17? First sentence of paragraph 17, Mohanlal?
It is 17, paragraph 17 and meaning.
The question of
The
drawing
question of
sample
drawing
at
of
the
sample.
time of seizure, which more
Question of drawing of samples at the time of seizure, which
takes
more often
place in
than not
the absence of the
taken
magistrate
place,
does
the
not
absence
in
of
the
magistrate
above
does not in above
scheme of thing
scheme
arise.
of the things arise. It is so hastily and according to section 52A4, the act samples drawn and certified by the magistrate in compliance with the
No, question does not arise.
act.
Question of drawing samples at the time of seizure more often than
Suffice to
not
say that there is no
take place in the
provision
absence of
in the act
magistrate.
that mandates
not in
taking
the
of
above
samples
scheme
at
of
the time
things
of
arise.
seizure. That is perhaps
This is
why the norm of
especially
the
when,
statute
according
claims to be
to
taken
52
samples at the time of seizure.
and certified
It
by
is
magistrate
made
in considered
conflict between the
under
statute
trial.
provision
For
governing
otherwise, we said
the
there is
taking
no
of
provision in
samples
the
and standing
that
orders for the
mandates
central
taking of samples at
evidence
the time of
meant
seizure.
to the place in the body. There is no mandate that such a conflict shall have to be resolved.
Meaning, that
There
is
was a
perhaps why none of the
because
states
of the
came to
petition.
taking
But the explanation of the deputy notification, the same form, found to be confidence, the mind of the authority, concerned instead of helping them out. The central government
the distinction
therefore
of
will
Corona in
to examine the matter
the
and take suitable steps.
question of drawing samples at the time of seizure, it will be like a sample, which offender does not, in absence of any, does not arise in the above scheme of things to go to 52A scheme to disposal of sample. য'ত 189 বেলেগ ধৰণৰ বস্তু লে ডাউন কৰিছিল যোনটো 52A2 বেলেগ এটা কৰিছে সেইকাৰণে 189 এই বুলি ক'লে লাষ্টত চেন্ট্ৰেল গভৰ্ণমেণ্ট would therefore do well to re-examine the matter. কিন্তু meaning হ'ব এইটো
More often than into the side question
Not-
of sample in the absence of magistrate does not arise in the scheme of things. 52A মধ্যে seizure of হলো drawing sample হব না।
সিজাৰৰ কথা নাই 52A
52 red line.
16, 17 and 18 we have to read again and again and
Interestingly,
see, two things are very clear. 52A1 gives you the power, central government, to issue notification, which you have done, 1 of 89. 52A2 lays down certain procedure. What do you need to do if you intend to dispose of the contraband? In Mohanlal, Honorable Supreme Court found that there is a conflict of 1 of 89 and subsection 2. And therefore, it has been held that notification is not okay. Legislature kindly look into it. But while saying so, something has been said about regarding drawing of samples at the time of seizure.
yes, sir, that has been
At the time of seizure. Now, 52A, is it connected directly with drawing of samples at the time of seizure?
Yes, it is.
trying to see.
See, saying yes is very easy, but you have to examine properly. Why is 52A is meant for? Is it at the time of seizure? Or is it for the purpose of disposal of the contraband?
No, at the time of seizure, as per the language of section 52, subclause A, subclause 2.
So that is 2. 2 comes after 1.
From one. One is regarding.
No,
that-
you cannot read independently.
Yes,
2
yes,
is the
of course,
condition
of-
precedent.
of
If you
course.
intend to dispose of, Under 1, you have to follow 2. Now, it may be a submission that 2 also the same mandate, same rigors you have to follow for drawing of sample for sending it to FSL. It may be a reasonable submission, but it is not directly, is it directly coming from 50 to 2 or 1 and 2 reading conjointly?
The statement of objection region, its close quote says that to provide for pre-trial disposal of the seized.
It's only for disposal.
Yes.
See the heading.
The heading is
Disposal of seized matter. And see the first sentence of 52
Yes, notification.
A1. The central government may, having regard to the hazardous nature, vulnerability to theft, substitution, constraint of proper storage or space, or any other relevant consideration.
That includes.
So if you destroy it, dispose it, then what do? You have
Yes.
to save the primary evidence. So this is what you are required to do so that it will be treated as a primary evidence irrespective of notwithstanding anything in any other law.
Mungilal,
See the language in 4,
Mungilal.
non-obstante clause, notwithstanding anything contained in the Indian Evidence Act, CR, PCR, any code.
Any code. Every code trying an offense under this act shall create the inventory.
And see, and if you follow the rigors of 2, then it will be a primary evidence.
Right.
Normally it is primary evidence means what? You have to, the things have to be before the court, but here is an exception. Considering the hazardous circumstance, the objects, the vulnerable to theft, substitution, you may dispose it of, but while before disposing, you have to keep samples, you may have to have an inventory list, get it
Yes.
certified by magistrate, photograph in the presence of magistrate, make a list will be primary evidence.
And section 52, but maybe also be important to consider.
52,
54,
54, please.
54.
Yes.
presumption from possession of illicit article.
Hmm.
In trial, under this act, it may be presumed unless and until the contrary is proved that the accused has committed an offense under the act in respect of A, any narcotic, drug or psychotic substance or controlled substance. B, any opium, poppy, cannabis, or cocoa plant growing and transformed. C, any apparatus specially designed for any group of utensils. Then B, any materials which have
Presumption.
been undergone. The presumption can be.
Presumption is only from possession, but other aspects you have to follow.
No, that is,
See the nature of the penalty, very stringent.
yes, Lordship.
So the procedure also have to be very meticulously followed.
Meticulously followed. That there is no contrary submission to that.
Yes. Madam has showed one recent judgment of Khalid,
Yes, that's fine.
wherein even the FSL report, how do you treat? You have to address that.
Lordship, the
One
facts of that case are quite different. Lordship, and your Lordship will see the facts of the present case, everything will be.
No, we'll definitely correlate the facts. Without the facts, we just cannot take up one line. But something has been said. How do you treat an FSL report so far as
That
NDPS
is-
substance is concerned?
That is there, Lord. If it is not followed, then it will be nothing but a piece of paper. But Lordship.
Not
whether-
piece of paper,
West.
waste paper.
Waste paper. Lordship, here. Lordship is to see whether after drawing sample, whether they are kept in safe custody. The purpose of drawing sample and sending the sample is that there should be not manipulation.
Exactly.
That is the purpose. So for the.
So how do you ensure? What is the procedure laid down? That see the even in the statute, the expression vulnerability to theft, substitution.
Yes, that is the purpose.
If these are happening,
One more also added in Mungilal, Lordship.
Mongilalo have read earlier.
No, justice
Para
are
six.
there, Lord. So is clear. There is no contrary argument in this.
Mangilal,
Mangilal.
Madhya Pradesh.
Mangilal, in para 6. This provision is to inject fair play in the process of investigation.
Stability, this is the purpose.
But see the facts of the other one,
Which one?
waste paper.
Waste paper is Muhammad Khalid.
Here also there was
Let us judgment loss between
lot of discrepancies.
2024, Five.
Latest one.
24, 5 SCC, 393. Oh,
Do you
390.
have the citation, Mr. Kyle? 2024 5 SCC 393.
Asan na? Yes, yes. Ito lang.
So Telangana.
Mm-mm. Telling. Same year also, Malkana registered was not produced in the court. In our case also, like Muhammad Khalid Lord. And does not disclose about funds. It can-
Paragraph 5 to lot fact has been stated.
मुद्दा मालूम subject even the property deposit in the court मुद्दा मुद्दा क्या है But you may be correct in Khalid, the 3 packets have become 7 packets.
Repackaging. That is the procedure during the sampling before the magistrate.
But it was taken exception by the court. How can 3 become 7? There can be interpolation, there can be substitution.
That is why Lordship, inventory is required in presence of the magistrate with mentioning all the items, how much the weight of the seized contraband.
Other than 52A2, is there any other provision in the statute?
In our case,
Is there any other provision in the statute?
there is no provision except this. It is mentioned in the, it is already decided in Mohanlal because of in paragraph number 16. In the act, there is, the act is silent to that read.
And what light will 2022 throw in this?
Apni koi 20.
That rules?
Not.
Disposal rules?
2020 rules.
2022 rules.
22 rules.
Yes,
Disposal.
rule 3. Classification
But
of
these
seizure.
rules are also for disposal only.
No,
Oh, Seizure storage, right, sampling,
There are-
right.
There are chapters. Chapter 1 is preliminary and second.
Chapter 2 is
Sampling
Seizure.
Interestingly, earlier the definition of magistrate was not given.
Definition of
Magistrate,
magistrate,
who
okay.
is the magistrate? Now it has been given, magistrate means judicial magistrate. Earlier it was not given. Then this rule has been
Definition is
stated in many chapters. Chapter 1 is preliminary. Chapter 2 is seizure and storage of seized materials. Chapter number 3 is sampling.
Here also
And
sampling.
4 is disposal.
Sampling part kindly peruse Lord.
Yes. 11.
No, it
From
is
eight.
8.
8.
Application to magistrate.
After seized materials under the act, it is forwarded to the officer in charge of nearest police station or to the officer empowered under section 53, the act, or if it is seized by such an officer himself, he shall prepare an inventory of such materials in form number 4, and apply to the magistrate at the earliest under subsection 2 of section 52A of the Act, form number 5. Sample to be drawn in presence of the magistrate after application to the magistrate under subsection 2, section 52A of the Act is made. The investigating officer shall ensure that the sample of the seized materials are drawn in presence of the magistrate. The same is certified by the magistrate in accordance with the provision of the said subsection. Drawing of sample, one sample in duplicate shall be drawn from each packet.
The provisions of 52A has been borrowed. Borrowed. Same procedure, 52A here also for.
Yes.
This makes it very clear that 52A is only for the purpose of disposal. And what do you need to do before disposal? These are the procedure in 52A2.
In a 22 Act, it is for sampling purpose also, Lordship.
That is it. For sampling also, the legislative mandate which was for 52A, those has been borrowed for even for sampling.
Yes.
Lord.
Sampling not for the purpose of disposal.
No, yes,
Sampling only for maybe for the purpose of sending it to FSL.
yes.
Then rule 13. Dispatch of samples for testing. The samples after being certified by the magistrate shall be sent directly to any one of the jurisdictional laboratory, the Central Revenue Control Laboratory, Central Forensic Science Laboratory, or State Forensic Science Laboratory.
And
But the case may be for chemical analysis without any delay. To the sample of these drugs or substance shall be passed to the fictional laboratory for cover. And some forms have been set.
But ultimately, substantively, the same thing is now been in the form of 22 rules.
Yes.
But nothing else. Form, something, these are very
That is-
technical.
Yes.
But drawing of samples, sending of samples certified by the magistrate,
That is
these are all in the same
conformity.
lines as 52A2.
That is
Which
That
is
is
summed
there.
up in Mohanlal's judgment. That is followed.
Mohanlal of which year? Mohanlal of
Mohanlal of 2016.
that's different. But after 2022, matter can be interpreted in a different manner.
that
Rules
is
of
not
2022 where 52A2 provisions have been borrowed and rather referred.
Yes.
So
But Lordship, that is in 1/89 also. In para 4. Standing order para 4.
yes, 89, 1989.
89 of Seizure before at the time by the seizing officer of provision to be made. GP Mohanlal Ekole, it is valid. So to bring rules in conformity with Mohanlal's judgment, a rule to enact. Make it in conformity with 52, which may imply that.
No, but in Mohanlal, the conflict was noticed or emphasized because it was a matter of disposal. Yes, no, 52A disposal থাকাত এইখিনি কৰিব দিছে তোমালোকে নকৰি পেলাই তাতে চেম্পল ল'ব কাৰণে নটিফিকেশ্যন দিলে কেনেকে হ'ল এইটো
General question.
এইটো কেছত যদি ডিছপ'জেলৰ নহ'লেহেঁতেন বস্তুখিনি নাথাকিলেহেঁতেন P1, P2, P7 যদি এক্সিবিট নকৰিলে কথাটো একদম ইজিলি প্ৰব্লেম
Proceeding the case. Is there any mandate for sampling waste? One for the purpose of disposal.
for the purpose of FSM.
Into scheme of facility. Because Dutch correlate tinkering or chances basic thinking.
Production এইটো product Kyle Mr. Kyle
Whether under the scheme of NDPS Act, is there any provision for taking sample twice? One for the purpose of sending the sample to FSL, other for the purpose of disposal.
Yes, Lordship, 52, it speaks about one, section 52(1).
No. 52 says you
52A.
have, 52A says
52A.
you have to take samples only before magistrates.
Not-
2 samples, one original, one duplicate.
Duplicate.
Our query is not that. Whether under the scheme of things, is there any statutory prescription mandate is there that you can take sample twice during the proceeding, during investigation, one for the purpose of sending it to for FSL examination,
Another for disposal.
another for while you were moving an application under
But in,
52A.
as per my knowledge was, in act, it is not provided, but notification is.
No,
both
that
the not-
notification is
Both the
against the mandate of 52A.
But if it was followed and, this is my simple submission, that, notification not interfered by either by Mohanlal or any subsequent judge. Since judgment also it was not considered, or High Court in judgment mandate that, either you have to follow 52A or, notification,
One of it.
one of it. In many judgment it is quoted.
No,
Oh,
how, Mr. Kayal, how the observation in Mohanlal may be interpreted when it says that there is no provision of taking samples at the time of seizure in the statute.
it is not there, was not there.
So the statute speaks about only once sample can be drawn.
No, if, I'm not, if my submission contrary to the law letter, but my submission before the Lord is that for Mohanlal, application 1 of 89 was in force. Till date, Lordship, till it was repealed in 22, that was in force. Yes, that is subject to interpretation by effect of the each and case. The main purpose of taking sample to maintain the sensitivity of the sample, that it should not be replaced or there should not be any manipulation with respect to sample. Here in this case, and Lordship, the case flow cited by my learned friend, Lordship is the effects of this case also. In that case, Lordship, the samples were drawn, 2 accused were arrested, and there was so many anomalies in that.
No, one aspect of one way of looking at it may be that under NDPS Act, sampling is to be drawn before the magistrate,
Yes.
which brings sanctity to the procedure. Another is sampling may be any seizing officer. So, is there any difference? Drawing sample before a magistrate and under what provision that apart from the 89 notification, the sampling may be done in presence of at the time of seizure without a magistrate.
Only notification of 1 of 89 was. Otherwise, the act is very clear. Lordship, I'm again stressing issue A1. This is considered by Lordship. The heading of the section 52A is disposal of these narcotic drugs and psychoactive substances. Central government may, having regard to the hazardous nature, vulnerability of theft, substitution, constant of proper storage space, or any other relevant situation in respect of any narcotic drug, narcotic substance, controlled substance, or substance by notification in the official gazette. Specify such narcotic drug, narcotic substance, controlled substance, or contains class of narcotic drug, class of narcotic substance, class of controlled substance, or contains which shall as soon as may be after their seizure be disposed of by such officer in such manner as the government may from time to time determine after following the procedure herein after. So everything has been kept on the comment.
Then why in 22 rules
Okay,
that provision was deleted, which was there in 89?
because there was a mandate of Supreme Court, so it was subsequently
What
You-
was the mandate?
Prosecution Mohanlal. That it will prevail over the notification, and the mandate was given to the government. Prosecution paragraph,
No, what was the provision before 52A was enacted?
except
It
act
was-
backup, there was no provision.
How samples were drawn and then?
There was another two notification, I protect. It was, there were another two notification, probably that way is regard to disposal.
22.
15 or 15
এইটো sampling আৰু 52A ৰ মাজত যোনটো fine distinction আছে, এতিয়াও legislature এই distinction
Oh, in Hindi though.
নাই,
Easy.
special portion of
Equal effect.
chapter 3
Equal
sampling,
effect.
সেইটো কিন্তু 52A পোৱা নাই যে disposal ক্ষেত্ৰত পোৱা নাই, কিয় পোৱা নাই মই দেখুৱাই আছো।
এটা তো আপনার হেৰি কৰি দিলে
Under
Regard to disposal.
এটা disposal of 15 or
Each of the inventory of such informed and applied on estate that is under subsection
Wait.
253A
88
inform
82
52A to মতে sampling of পিছত হেৰি কৰিব দৰখাস্ত দিব এই দৰখাস্ত কিন্তু হেৰি নহয় না under subsection 2 of 52A এই দৰখাস্ত কিন্তু disposal হ'ব নহয় কিয় নহয় মই কৈছো disposal chapter 4
এটা আছে মোটা পায়রা এটা এটা আছে
Having said the offices of the company,
disposal
but they are referring to only 53 and 52A. No, no, 52 nine. Office of the 53.
Disposal of
52 is to empower and এটা ডিফাৰেন্স দেখিছো এই দৰখাস্তখন কৰিব চেম্পলিঙৰ কাৰণে বাৰু কিন্তু তাতে মেণ্ডেট যে এই দৰখাস্তখন ফ্ৰী আণ্ডাৰত মিউনিচিপালিটি হেৰি কৰিব ইয়াতে কৈছে ইয়াতে কৈছে চব and they are used to allow the application under the regarding disposal. Get it, either on October approximately. After the sale. You have the Act of Rules of 2022, which you have just handed over.
Yes.
Read 8 and 9, which comes under the chapter 3 of sampling. Madam, you have
Yes.
8 and 9. Read very carefully and
Eight and-
immediately read.
Application to magistrate.
No. First, chapter 3 sampling.
Yes.
Yes,
It is under sampling.
Sampling.
Kindly note. Then chapter 4 is disposal.
Yes, sir.
And next, chapter 4 disposal and read 17, read 18. Read 18.
18.
First you read 8 and 9, which is under sampling.
Yes, application to magistrate. After the
You are
seizure,
reading 8.
8.
Yes, please read.
After the seizure,
After the seize.
seized material under the act is provided to the officer in charge of the nearest police station or to the officer empowered under section 53 of the act, or if it is seized by such an officer himself, he shall prepare an inventory such materials in form 4 and apply to the magistrate at the earliest under subsection 2 of section 52A of the Act in form number 5.
Why is this application? Kindly read, this application is for his certification.
Yes,
Then kindly read 9 regarding samples.
sample to be drawn in presence of the magistrate. So application to the magistrate under subsection 2 of section 52 of the Act made, the investigating officer shall ensure that the sample of the seized material are drawn in presence of the magistrate. The same is certified by the magistrate in accordance with the provision of the said subsection.
This is only relating to the samples.
Yes, sir.
Now kindly come to
15.
Rule 18, which comes under the chapter of disposal. Kindly read 18.
The officer empowered under section 53 of the Act, or if the magistrate of the materials
Material.
are seized by an officer himself, he shall apply to the magistrate under subsection 2 of section 52A, the Act, form 5, at the earliest to allow the application under subsection 3 of section 52 of the Act. 2. So the magistrate allows the application under subsection 3 of section 52A, the Act, the officer referred to in sub-rule 1 shall reserve the
So this takes care of the requirement of 52A2
certificate.
for disposal only. Sampling does not even talk about 3.
So about 1 also.
No, sampling, the sampling 8 and 9 does not even talk about subsection 3.
Yes, sir.
So there is a distinction.
There is a distinction.
Only when disposal.
Statutory provision 52A, the application to go. You have to allow.
It took 52A who is it?
Rules 52A apply for it as per rules 52A apply for it. Statutory provision 52A application. 52A plus 3 allow for the. So really, the rules does not say that application has to be allowed.
It to disposal allow order
This
to.
is not specifically which
who is allowed? Now, magistrate, he shall apply to the magistrate so of the earliest to allow the application also.
gives emphasis on the
Applying officer. Applying officer, that you make an application to so that it can be and make a request for allowing it at the earliest.
yes. So, it's in the applying officer, you can apply to the sampling application and yeah, one
Hello, could you bring me check? Under the hospital after application.
because of
Suppose we don't mention magistrate. Procedure, এখন application কি? এখন sampling of নহয় না, এখন to inventory এখন application for inventory shall prepare inventory and apply to ministerial sufficiency. Inventory এখন certify করে বলিব। এখানে drawing of sample and then the magistrate. এই sample to very পঠিয়াব বলিব। এটা FSL এর বলেছি নাকি? It was a 13. Samples after being certified by the magistrate shall be scanned directly. এখন দরখাস্ত দিব ইনভেন্টরি সার্টিফাই কৰিব লাগিব স্যাম্পল টু মেজিস্ট্ৰেটৰ সন্মুখত ড্ৰ কৰিব লাগিব আৰু সাৰ্টিফাইড স্যাম্পলছ খিনি
So 22 makes it clear that samples have to be certified by magistrate. Only those samples are valid samples.
আগতে সেইটো নাছিলে মই তাকে চলো না আগতে 3 কৈছিল কি সিজিং অফিচাৰ সো এণ্ড সো shall make patch who should dispatch samples of seizure officer to one of the levels. There is no involvement of magistrate.
89 interpret করতে পারি যে sample has to be moved for the particular program. Sample has to be
It will ultimately stated because my rules of mind, sir. ইয়াতে সেইটোতো অহা নাই ইয়াতে আমাৰ এইটো কেছত FSL পঠোৱা চেম্পলটো মিনিষ্টাৰ চাৰ্টিফাইড নাছিল নেকি হা কৰিছে নেকি These madam the samples which were sent for forensic examination, was it certified by magistrate? In your case, wasn't it certified by magistrate?
Samples not certified by the way.
Where is your ground? What is your case on this? That is not your case. We have not seen such a foundation in your defense. Mr. Agarwal, I think you can, we'll fix a date in your case. We don't want to unnecessarily detain you. We'll fix a date in his case. You are there also? No.
No.
Okay. There were other counsels also. Have a date of your convenience. We will not detain you otherwise. This is going to take some time. আমি লিখিলাম ডেটটো লিখি দেব পিছত দি দিলে হবে Tell us a date of your convenience. Tell us a date of your convenience. December. 4 December. 4 December we can try. You are also there, Mr. Borthakur. 19th of this month. Not be possible. 19th we have matters. We'll fix on 4th of December. Okay.
I have another 7 to 9. Not the date prepared.
No, connected matter.
No. Different.
You are there or not in Mr.
No, I am not.
Okay. First, both you. And the other. Okay, only you are there. Okay. 4th, huh? 4th. Positive time. Your matters?
7 to 9.
Huh? 7. Date reference.
Date prepared. Your lordship, can it be on week starting from 9th of
9th?
9th of December, week starting from any date of your lordship?
We'll have it on 10th. 10th.
Yeah.
Okay.
10th.
There are other councils also. Madam, you are there also.
My number 11 first.
Separate matter. Oh,
Item number 11 for hearing.
Madam,
And the evidence for it.
okay, you try your luck. We have not completed. There was a request made by Mr. Sharma. I will try to see what can we do in his case. Or if you want, you can give your date if you want. It may not be possible 3 o'clock. Interview to interview. We'll give a date. Don't worry. Item number 11. 11 to 11. We'll give a date. Okay, Mr. Kyle, what do you do? Like to see, make some, but
If possible, of Tuesday.
Tuesday. Tuesday, but kindly look into these aspects. It's you really need to apply your mind.
Sure.
Under what context these were.
I'll address.
Paucity of time did not permit the matter to be taken up wholly. only on request, list on 19th. Or Baki itu? Baki. 5 and 6. 5 and 6. Okay. On request, list for hearing on 4th of December. 7 to 9. On request, list for hearing on 10 December. Okay. 11 to 11 to 11 to
Madam, is
11 to 11 and 13. 11 to 11 December.
Madam, is it a matter of pardon? Keeping
We are not saying part. We should be there. We'll continue.
all right.
You can take back your because the next day you can give it back.
Lord.
কিছুমান হেৰি আছে মাংগিলালটো তেখেতক দি দিব পাৰিম আমাৰ এই citation to তেখেতক দি দিব পাৰে পিছত kindly hand over the citations in the next date. We are giving it back. And 22 rules তেখেতক দি 22 rules
I placed.
22 rules আমাৰ ফটোকপি করে তো কৰি থৈ দিব পাৰে 189 খুল কৰি থৈ দিব
Lordship may keep it. Lordship. We have the copy.
rules খিনি থৈ দিলে
If request 1/89 is also there. If requested, I can.
আৰু এখন এইটো তেওঁৰ আৰু the rules আৰু এখন আছে রাখেন কিবা চেষ্টা এটা কৰোঁ কি আছে ধৰণৰ থাকি গ'লে ইয়াতে বন্ধন থাকি গ'ল Mr. Kotoki, for which matter? We've given a date, I think 11th. 11 দিলো না এটো How are you connected? Madam is for America's, you're for the other side. Not the other side. Don't take the risk of being on the other side. Consequence may not be very good. এইটো নহয় এইটো মেনশন যে কৰিছিল দেন বিপিএসে মাথা খালে নিছেন There is no coordinated flow procedure there.
I think 12th, he can proceed. I'll reply on Monday or Tuesday, but because I don't.
You're making a mention. He said that he's been trying for this matter. How many witnesses?
Not too much witnesses, Lordship. Only one witness is relevant, Lordship. Here, the main fact is the Lordship, inquest report is missing, Lordship. And
You're an amicus.
no, Lordship,
Regular appeal.
regular appeal.
Three 302.
302, Lordship. In 302, Lordship, I will go from the first, Lordship, but the main fact is that inquest report is also missing, and there is some discrepancies in the witness report.
Inquest is missing.
In
How
fact,
was it taken care of by the learned judge?
they have not given any iota of this. They
No,
have
no.
not-
How was it taken care of by this point? That inquest report was not there,
It was not dealt with,
not dealt with.
not dealt with.
Did you raise the issue?
Lordship, that issue was not raised. Actually.
What are the case laws?
Yes, Lordship, I have the case lost.
Madam, what would be the consequence?
Here, Lordship,
The absence of inquest is always not fatal.
That is it. Now, will it be will the foundation go? I don't
Hmm.
think foundation will go.
Lordship,
It
here
may be one of the
one major
circumstance.
one major discrepancy is also there. Eyewitnesses say the victim was hit by one of not eyewitness. One of the witnesses says that he was hit by bottle in the head. But medical report, the forensic postmortem report says that he died due to strangulation.
Strangulation.
But no witnesses say on that part. That part also are not there.
Hmm.
Here, lots of various discrepancies are there regarding. I have formulated a point, Lordship. In short, Lordship, I can say that there is
No, there is no shortcut in criminal
and
appeal.
then I will start, Lordship. May I start, Lordship?
You have to go by from the FIR.
Yes, Lord. The FIR is from the paper book, Lordship. FIR is on page number 1, Lordship. So it is the form, Lordship. Here I'm going from that part, Lordship, that point, Lordship. The FIR was FIR number 233, 2024, Lordship. And here information received is say 22/7, 2014, and the GT entry number is say 644. Which was never been executed, that 644 GT entry number. Then this was being here accused name is there. Shahzan Ali, Saddam Ali, Mainul Ali. Here, Lordship, I take permission from
What
this.
is your name?
My name is Mainul Ali, Mainul Hussain.
Alas Minor Ali.
Yes, sir.
Please read the Azhar.
There is the accused Mohammad Shahzan Ali, Saddam Ali, Mainul Ali, and 2 others whose names are not known. All are residents of PS Mayang, district Morigaon, Assam. Their humble submission is that around 3:30 p.m. on 27, 2014, the accused person hired a new also 800 vehicle of my friend Abhimanyu Biswas from Zagirot taxi stand in order to go to Nagaon. On the way, Abhimanyu also picked me up from my home. After that, the accused person finished their work at Nagaon and Akashi Ganga. We arrived at Zagirot around 9 p.m. Then, on being asked by the accused person to drop them at Poha market, Abhimanyu again went to Poha. On the way to Poha at Kadamtoli, the accused person picked up 2 more unknown persons in the vehicle. When we reached Nabhavatia, I saw the accused number 2 Lordship. This accused number 2 is a juvenile, Lordship. So should here name is been given, so I can spell the name, Lord.
No, we are not on accused number 2. We are mainly on
Not
minor.
in the part, Lordship. Accused
Okay,
number his name is written, Lordship.
Okay, doesn't matter. Okay, then.
Okay. Accused number 2 dealing blows on the head with a glass bottle, and then out of fear, I opened the car door and jumped from the moving vehicle. As the accused person tried to strangulate me, that is the informant, I became unconscious. When I regained my senses, I made a phone call to my home from home situated nearby and informed about the incident. My family members rescued me with the help of Zagirot PS. I came to know around 9 a.m. on the following day, that is 21/7/2014, the dead body of Abhimanyu was discovered from Nokura forest. The accused person had fled, taking the vehicle with them. Since it is evident that the accused person conspiratorially took the vehicle on hire, and not only did they injure me, but also kill my friend Abhimanyu, I therefore earnestly request you to take necessary steps after investigating into the matter. It is worth mentioning that here that as I was busy in cremation of the deceased, the lodging of the Azhar got delayed. But after that, charge sheet was filed. But before that, before being charged, the police
This Pankaj is PW what?
PW1,
1.
PW2 lot. Pankaj is PW2. Before filing of the charge sheet, lot sheet 168, police took go for 164 also of Pankaj Devan. 168 paper. And sequentially 168 the lordship, it is 164 May here lordship, my address are mentioned above. I am around 3:30 p.m. I went with my friend Abhimanyu Biswas to Akashi Ganga, Nagaon in his Alto 800 vehicle, taking along 3 persons, Shahzan Ali, Moinul Ali, Saddam Hussain. We were at Akashi Ganga for about 1.5 hours. After that, we returned from there and arrived at Jagirot at around 9:30 p.m. Then Moinul asked Abhimanyu to drop the Poha, as it was already night and they would not get any other vehicle to go. Therefore, Abhimanyu got ready to go to Poha and we proceeded towards Poha. On the way, Moinul asked to stop the vehicle at Kadamtoli and took two more persons with them. Abhimanyu opposed, but Moinul said that they were staff of a stop. After that, we again started our journey, and when we reached Nabavatia, Saddam dealt a blow on the head of Abhimanyu with a glass bottle. That is a glass bottle. On seeing that, I got frightened and jumped from the moving vehicle by opening its door. Immediately, Saddam and two other persons who boarded the vehicle at Kadamtali. It is not myself, Lord. Saddam and two other persons who hit the Pankaj Jarma. There are two parts, Lordship. Here, Abhimanyu, the informant was also hurt, Lord. So that part, he exonerated me in 164, Lord. Immediately, Saddam and two other persons who boarded the vehicle at Kadamtoli came running towards me. One of the person who boarded the vehicle at the Kadamtoli sat on my chest, while the other strangulated me, and Saddam asked them to cut my neck. Then I pretended to be dead, thinking that I had died due to strangulation. They dragged me near the road and leaving me there, they left the spot. After that, they had left. I went to a residence located nearby, took a mobile phone from them and made a phone call to my house. About half an hour after, three persons, Gopal Sunar, Dulal Das and Postu nickname, came, and half an hour after that, the people of my house arrived here with police. Then police came. We all made a search for Abhimanyu in the night itself, but we could not trace him out at night. Yesterday, Gopal Demnath and some others recovered the dead body of Abhimanyu and Diprang River. In the morning today, police recovered the also 800 vehicle of Abhimanyu. After that, Lordship, police proceeded the case.
PW1.
No, proceeded the case, Lordship. Page number one.
Why do you need?
One PW1. PW1 is a Rajan Deka who turned hostile, Lordship. Occurrence took place around 1.5 years back at night hour. At that time, I was sleeping in my home. On the following day, some small children of our village told me that at night some people came to my home. At that time, at this stage, the witness is declared hostile. It is not a fact that I have stated before the police that on the eventful night at 11:30 p.m., somebody had made knock at my door and called uncle, uncle. Then I opened the door. After that, he asked me a glass of water and I gave him a glass of water. After drinking water, he told me that he was traveling in an Alto car with his friend towards Poha side. The car was driven by his friend and somebody struck the head of his friend with a bottle. Then he got frightened and came out of the car. This is a turn hostile, but this part was never being. I will come later on, Lord. Regarding this part, Lord. After PW1, 2, he is the person who accompanied the vehicle, Lord. I am the informant of this case. I know this is Abhimanyu Biswa. He was my friend. I have seen Moinul Haq and Saddam Hussain on the day of occurrence. Rest are not known to me. Occurrence took place 2 years back. It was 20th of July on a particular Sunday. On that day at 3 p.m., I received a phone call from Abhimanyu and he told me that he was going to drop 3% at Nagaon. And on return, as he will have returned alone, he asked me to accompany him. This had an Alto 800 car and he used that car commercial. He had told over telephone to stay by the roadside. Then I came by the roadside. After around 5 minutes, he came. I have seen 3 persons occupying the rear seat of the car. Abhimanyu was at the driver's seat. The front seat near the driver was vacant. I occupied that seat. Among 3 persons, 2 were Saddam and Mainul. I do not know the other. Then Abhimanyu started the car and we started proceeding towards Nagaon. When we reached at the point of the bypass, Abhimanyu asked them about how far we could go. They replied that they have forgotten the exact place and told Abhimanyu to proceed further. Then the car moved to Doboka side. After some time, we reached Akashiganga and the car stopped there. There, 2 of them got down from the car and went to a house. Saptam remained seated at the vehicle along with us. After some time, one of them came and told us that it takes some time. Then we took refreshment at nearby hotel. After some time, they came out and told us that the work is over. After that, we started our return journey. Then at Yamsui petrol pump, oil tanker was filled up. We reached Zagi Road at around 9 p.m. Then they told us to take them to Poha. As the time was odd, as they would not find vehicle to Poha, then we started proceeding towards Poha. They got down and take some refreshment. After we went towards Poha, on the road, there were 2 persons standing by the roadside. Person sitting on the rear side told Abhimanyu to stop the car and take them. Abhimanyu was reluctant as there was no sitting space. But they insisted and both the persons got in the car. One of the persons standing at the roadside occupied the middle seat in front, in between myself and Abhimanyu, and other took the rear seat. When we reached near Navavatia, I heard a sound of bottle and I turned around. Then I have seen Saddam holding a bottle in his hand and blood was coming out from the backside of the head of the Abhimanyu. He was injured, Lordship. Then I opened the door and jumped out of the car in panic. Then the strange doctor, he jumped out of a car. Then all the persons came and hold me tight. One person grabbed my chest and one of them got seated on my chest. One of them started strangulating my neck. One of them shouted that my neck should be cut off. Then they thought that I died that time. They kicked me aside and left that place. After that, I was lying on the ground for 2.5 hours. Here in this case, Lordship, the informant accused all the persons, including myself. After regaining my senses, I started walking. That was deserted place. After 500 meters of walking, I felt very weak. Then I went to a house and called the person of that house. Woke them up and narrated the incident. Here I had a glass of water. Taking a mobile phone from them, I called my uncle Ajit Devnath. After 1 hour, police came followed by my uncle Ajit Devnath. They took me back to the place of occurrence. Then we made search for Abhimanyu there, but could not find him. After that, we went to Poha and there we searched for Abhimanyu. One village person told us that one white car crossed that road around 2 hours ago, but we failed to find him. On the following day, we got information that the dead body of Abhimanyu is recovered from Poha Doloni. I have seen the bottle in the hand of the accused Saddam, and he struck that bottle on the head of the Abhimanyu. And as a result, Abhimanyu sustained head injury. Then I lost this FIR. This is Exhibit 1, and FIR is his signature. The dead body was found on the following day of the incident. It took time to lodge FIR as I was busy in cremation of dead body of Abhimanyu, and my family members restricted me to venture out in fear. During investigation, I made statement before the court. Exhibit 2 is the state statement. That is 164 statement, Exhibit 2. And the cost examination part, Lordship. I have completed the final examination of BCom. The disease studied up to 8 or 9. Thereafter, he dropped me out of the school and started driving auto.
He dropped out.
Oh, sorry, he dropped out. He dropped out from the school and started driving auto. After that, he started driving car. There was no registration number of that car. It was a new car. Abhimanyu purchased that car in the name of his mother. This was my close friend. I have not seen Saddam before the incident. I have seen him when Saddam was sitting alone, when other two got down and Akashiganga from the vehicle. I had an interaction with Saddam. It was a formal introduction. At that time, I did not suspect his intention. The 2 persons standing by the roadside gave signal to stop that vehicle. Both the person and the person seated in the rear seat were from same village. I have not noticed that if they exchanged the seat, one of them took the middle seat in between myself and Abhimanyu, and other took the rear seat. I cannot say if the bottle belongs to Pepsi. It was glass bottle containing cold drink. Bottle was broken. After I heard the sound, the head of the Abhimanyu was flinged towards right. I have seen the bottle in the hands of Saddam. I have not noticed if Saddam hit the bottle on the head of the case. If Saddam is, no blood was still on my body. I jumped out of the car. When it was running, after that I came out of the car. Other person came out and chased me for 50 meters. After that they caught and held me. I started using mobile phone from 2009. While I was in the car, the mobile was in my pocket. When I regained my senses, I found my mobile phone missing. I informed the police agency regarding the disappearance of my mobile, but it was not found by police agency. It is not a fact that I have not used the mobile phone of the person in whose house I went that night. It is not a fact that in my statement that I made before the court that I stated that the bottle was made of plastic and it was of Pepsi company. I made statement before the Juvenile Justice Court that in the statement I have stated that I took a Pepsi bottle, drank a portion of it, and rest of the portion was given to Saddam. The bottle I bought was made of plastic. It was a bumpy road. The speed of the car was around 30 to 40 kilometers per hour. While I jumped out of the car, initially I did not feel that I got hurt. Subsequently, I came to know I got injured because of jumping from the running car. When I was strangulated, I felt pain. I went to doctor for treatment. It is not a fact that Abhimanya did not sustain any injury on head. It is not a fact that accused person did not commit any crime. I cannot say the exact date when I was brought to court. However, I came to the court after 2-3 days of the incident. On the night of the incident, I was questioned by the police. I have not mentioned anyone's name in the statement recorded by police. I have not mentioned anyone's name in the statement recorded. It is not a fact that I have not stated before the police when we reached Akashiganga, Abhimanya, Saddam and myself remained seated in the car and other two got down. It is not a fact that I have not stated before police that I heard a sound of bottle and when I turn around, I have seen blood coming out of the head of Abhimanya and Saddam was holding a bottle. It was not a fact that one of the accused cried at my neck should be cut. Azhar was drawn up by person of Dhagi Road, who was brought by police to the police station. He drew up the Azhar as dictated by me in presence of police. I named 3 persons in the FIR. Police told the name of other 2 accused persons apart from Saddam. Here, Lordship, he stated police told the name of the other 2 accused persons. It was police apart from Saddam. I was not tutored by police when I was brought to the court. The OC at the time of drawing up Exhibit 1 told me the address of the accused. I have seen Shahjahan on the date of the incident. His name was told by police. It is not a fact that I am engaging in illegal activity, including theft of vehicle, as tutored by police, and others I inserted the name of the accused in FIR. I have no knowledge if any family member of the deceased file a FIR. It is not a fact that I have confronted the incident and filed Exhibit 1 FIR, keeping the family members in dark. On the following day of the incident, I was called by the police to PS. I have forgotten if the police took signature in any paper on that day. If one have to reach Poha Dulani, one have to cross Poha. Then the question by the court, Lordship. You have told that name of the accused person in the person inserted in the FIR were told by police. Where from the police get told them? At the same time when I went to PS, I have seen Saddam there. I identified him as the person who injured Abhimanyu. Then police interrogated him. After that, police told me a name of the accused. Only Saddam. It is not a fact that I have not seen anyone at the PS. It is not a fact that Saddam did not tell anyone's name. I cannot say Saddam came to the PS. He came to the PS along with 2-3 persons. I have seen Saddam at PS after 2-3 days of incident. Saddam informed police about the accused person and police told me the name of the 2 other persons that I included in the FIR. It is a police lordship. Saddam informed the police about the accused person and police told me the name of the other 2 persons that I included in the FIR. My name was included at the instance of a police lordship. It is not a fact that I have not stated before the police in any statement in before the court which about this matter. Then Lordship PW3. PW3 is the Aussie theft, Lordship. I know the informant. The disease Abhimanyu Biswas. Accused person are not known to me. Occurrence took place 2 years back. PW3 Pankaj Devnath is my nephew. On a particular night at 10 p.m., I received a phone call from Pankaj, who told me that he was at Navahaya and asked me to take him from there. At that time, his voice was quivering and he was not properly speaking. He went there with disease Abhimanyu.
He is the uncle of the informant,
Yes, Lord.
Ajit.
Devnath. Then at that time, his voice was quivering and he was not properly speaking. He went there with disease Abhimanyu. I thought that the vehicle must have met with an accident. Then I called one of my nephew, namely Tinku Devnath. Then, accompanied by some other person, I went to the Zagir's PS and reported the matter to the police. Then, accompanied by police, we went to Navavatya. There we found Pankaj in the house of a particular person. This person is become hostile lot. This particular person, Rajan Deka, is being
First, PW1.
PW. After that, we started searching from the vehicle and Abhimanyu. At that time, he was questioned by police and I did not interact with him. We could not find the vehicle and Abhimanyu. We have found Pankaj in an injured condition. After that, we returned to Zakir. Then Pankaj was medically treated. After that, we again went to Navavatya in search of Abhimanyu and vehicle, but we failed to locate them. On the following day, I came to learn that the dead body of the Abhimanyu was found somewhere in that area. When Pankaj was interrogated by police, he told police that Abhimanyu was assaulted by some persons and Pankaj was assaulted by them, was also assaulted by them. Then he jumped out of the vehicle and again he was assaulted. Thereafter, he lost his senses. After some time, he went to the house of some person. Some person took shelter there. I don't know who assaulted Pankaj. Tinku Devnath, Vijay Mohandas, Sujit De, Bapi De, nobody was a witness lot. Made a part of the investigation. They have never been interrogated. Person went to the PS along with myself. I have forgotten if any written complaint was given at the PS. I have verbally informed the matter to the police. Police recorded my state. It is not a fact that I have not stated before the police. I have seen injury marks on the body of Pankaj and Pankaj and Navat. It is also not a fact that I have not stated before police that Pankaj was assaulted by means of bottle and he jumped out of the car and he lost sense. I verbally informed the matter to police regarding receiving a phone call from Pankaj. The mobile number from which I received the phone call was not belongs to Pankaj and I have not informed police regarding to this phone number. I have not stated before the police that Pankaj was dropped from that vehicle. Pankaj resides in our house. We have 11 family members in our house, including me and Pankaj. It is not a fact that Pankaj have not made any phone calls to me. Then Lordship, this Abdul Jalil, this is a part of the
No, the mobile number
Lordship.
from whom I received the phone call does not belong to Pankaj. This is correct. Pankaj never said that he had made, he said that his mobile was taken away by them. He
Yes, Lordship.
used somebody else's phone by
Lordship.
knocking the door.
Yes, Lordship.
And maybe it was Rajan Deka's place. Rajan Deka had, however, turned hostile.
Turn hostage.
Because
Rajan Deka has
From
turned
the
hostage.
suggestion given, allegedly he said to the police that so-and-so came, have a glass of water, frightened,
Lordship.
then made a phone call.
Yes.
That he has negated.
That negated. Lordship, that Rajan Deka part is very important, Lordship. This Rajan Deka part was exhibited in a IO statement, which is missing from the paper. So I will go through it. And it will,
But Rajan Deka has denied.
but no, Lordship, it does.
Suggestion here, if he had said that, yes, I had said before, then
No, Rajan Deka is an important part of the. This is a let me complete.
now how is Rajan Deka significant?
Because to complete the chain, Rajan Deka is important lot. And police tried in the, if you go to the PW 13 lordship, police has given, exhibited the Rajan Deka statement lordship.
That will not take taken into account. Making a phone call from Rajan Deka's phone number or some other will not make a significant change or difference in the
Lordship,
case.
yeah. Okay, lordship, that part I.
And otherwise, also he's been declared hostile.
Lordship.
And the suggestion also he is negated.
Sir.
Okay, please proceed.
Because the lordship, the witness, as this is a this is based on circumstantial evidence, sir. Because if we, there's Pankaj cannot be termed as a sole witness, sir, because he's jumped out of the car. And it is being opined by the trial court judge also. Because he has not seen. after jumping out of the car, he has not seen what happened to that part. And out of the 5%, 2% is being acquitted. Similarly situated. Here, Lord. Here, along with Mainul, 2 other person was also there. They are being acquitted.
Acquitted on what basis?
Acquitted. The reasoning is that no depth of reasoning in there in the judgment, Lordship. So I similarly, exactly similar, because Lordship, in the vehicle, Mainul was there, Saddam was there, and Shahjahan was there. From the roadside, 2% has boarded, Lord. And after that, what happened? After boarding, they went there. They called Pankaj Datta, PW1, PW2 witnesses that victim was hit by a glass bottle in the head, and he jumped off the car and he ran away. And when running away, he has an inconsistent statement in the 164. He stated that Moinul was sitting in the vehicle. Other Saddam and the 2% who had boarded roadside had hit him, hit the informant. And after that, he don't know anything. So after that, what had happened? The victim was in the vehicle, and who killed him? It was never been examined. Who killed him? Nobody knows. So he was not the witness. He is not the sole witness. It is purely based on circumstantial evidence. So prosecution has to prove it beyond reasonable doubt the link, Lordship. And for that purpose, Lordship, IO has given the statement of the Rajan Deka in his statement, Lordship, as a exhibit 11, Lord, and which is missing, Lord, from the paper. So here, Lordship will find another interesting fact.
Paper book history, page 161 will be there in the records.
No, Lordship, but here it is said 164 statement in the paper book. Lordship can go through it.
164 at page 168 is there.
No, I have that's there because could not find it, Lordship.
What was not found?
That is serial number 41, Lordship, in the index, Lordship.
Page 168.
No. Serial number 41.
What is that? Statement under?
Statement of witness under section 164 CRPT exhibit 11.
That is a part of the paper book 168.
No, Lordship.
You have read it?
No, Lordship, it is not found, it is said.
Then how did they make it the paper book?
No, Lordship, I will come systematically, Lordship.
No. How was it then made a part of paper book?
That is, yeah, Lordship, I hit 164, that is being recorded, that is a separate. Lordship, I'm in that case, I'm page number 33. I'm reading page number 30. Page number 33, IO statement, Lord. Here,
Just a minute. Center witness. And this index, how does it make a difference? Whose 164 statement?
I don't know, Lord. That
So
is
how is it material?
that
Silk
I
index.
that will come. That I will come, Lord. There are various costs.
Statement.
Lordship can go page number 35. Page number 35, Lordship will get. Page number 35, Lordship will get.
No, 160, that is PW1. Informant. Sorry, PW1, PW2. Pankaj Devnath, informant.
30. That 164 is 32 serial number. Index.
Page 168,
Yes.
that is the 164 statement
Yes.
of the informant.
Yes, 141 is missing, Lord. 41. Yes. Exhibit
Billing.
11. Exhibit 11. It will come later.
164,
Some other with
what a witness.
Lord, I will go, Lord.
not found. Not found papers.
Is the witness of the Rajan Deka, Lord, actually.
PW1.
Now I will go PW4 Lordship. May I read Lordship?
Yes.
PW4, he is Abdul Jalil,
Page,
18 Lord. I don't know either the informant or the deceased. I know accused Ruhul and Baharul, who are in the dock. Both of them are of my same village. Occurrence took place around 1.5 years back. I am Sarkari Gaambura of Kasaribai village. At that time, I was serving as same. On a particular night at 3 a.m., police personnel came to my house and they took me to the police vehicle and asked me about the house of the Baharul. Then I led them to the house of the Baharul. Police arrested accused Baharul. After that, here also this part is very important. Police here, the Gaambura said, I led them to the house of the Baharul. Police arrested accused Baharul first. After that, police asked me about the house of the Ruhul. Then I again led them to the house of Ruhul. They arrested Rahul. First they arrested Baharul, then they arrested Ruhul. That part. This is part of the 27 of the evidence that Lordship they want to rely on.
27, leading to evidence. What?
The disclosure statement. They have they are stating that I will go. That part is important. Lordship.
How is it 27? Guambura was not an accused.
No. Gaambura is not an accused. He's a witness. Seizure witness. Lord. He's a
So
Seizure.
how does 27 comes in? What is
What?
27?
Lordship.
27 disclosure by an accused leading to a discovery. Neither this Guambura is an accused, nor is it led to
No.
discovery.
I'm not.
It has only led to the house of an accused.
Lord.
Yes, then
Then they took both the accused Aguirre after arresting the accused. Police allowed them to go after around half an hour. Police of Borsala police outpost again called me and told me that a vehicle was being recovered in front of Mahamara LP school. I made no query regarding the vehicle. After half an hour, police vehicle came to my house and took me to Mahamara LP school. I have seen one Alto car of white color standing near the boundary wall of the school. Police seized that car in front of Exhibit 3 is a seizure list and Exhibit 3.1 is my signature. Police personnel also found one mobile phone near the seat of the driver. The state mobile was seized. Height Exhibit 4 and 4.1 is my signature. Material Exhibit 1 is the state mobile handset. Today that mobile handset displayed before me, I can identify that. Dear Lordship, the distance between the house of the accused person and the place of where from the seized articles are recovered is 5 kilometers. I have not seen either the accused person at the time of seizure of the seized articles. I put signature in the exhibit as seizure list was blank paper. Nothing written on it. Then Lordship, then again Nurul Islam. I don't know he also one of the yes. I do not know the informant and the deceased. Occurrence took place around 1.5 years back. On a particular night, police from Barchola outpost came to my house and took me to Kasaribari Sarial. At that time, 2 other vehicles were along with the vehicle of Barchola police outpost. The other vehicles belonged to Zagirat PS and Lahorigat PS. From one of the vehicle, one Moinul was brought down. Police asked Moinul about the house of the accused Ruhul. Moinul led police to the house of the Ruhul. The police arrested Ruhul. Therefrom, police went to the house of the Baharul and arrested Baharul. Baharul and Rahul were taken by Zagirat PS and then Bortola police took my signature on a blank paper. At that time, Abdul Jalil Gaambura was also with me. Here, in the seizure list, they have stated that on blank papers, he was asked to sign it. He has signed it. Then a police vehicle came and I was taken by them. I led police to Mahamara LP school. On reaching there, I have seen one white numberless Alto car standing near the boundary wall of the state school. We have also seen one mobile handset, which was under the back seat. Then police called 2-3 VDP members from Mahamara village and handed over the car. Material of Exhibit 1 is the state mobile phone, which was spotted under the back seat of the state car. Police seized the mobile and the car. Exhibit 3.2 and Exhibit 4.2 are my signature. Exhibit 3.4 and Exhibit 3.4. I have not seen any of the accused at the place of recovery of the car. The distance between the house of the accused person and the place where from the seized article recovered is 5 kilometers. I have not stated before the police that at the time of two other vehicles were along with the vehicle of the Borsola police outpost. The other vehicles belonged to Zagirat PS and Lahorigarh PS from one of the vehicles. On Moinul Ali was brought down. Police asked Moinul about the house of the Ruhul. Moinul led police to the house of the Ruhul. There police arrested Ruhul. Therefrom police went to the house of Baharul and arrested Baharul. Then Lordship, another one is that Fakhrul Islam. I don't know the informant as well as the accused person about 2 years. Page 22. Therefore, he needs to visit places in case of requirement. On that particular day, as my father was ill, therefore I went to the police to that particular site. I saw that a wheeler vehicle was standing in front of Mamora LP School. The state vehicle was seized by police in front of me and other people, and my signature was obtained in the seizure list memo. The exhibit 3 is the state seizure memo. Exhibit 3.2 is my signature. Exhibit 4 is another seizure list. Exhibit 4.1 is my signature. I know this much. I did not find any person inside the vehicle. I did not find any mobile phone recovered by the police. I did not see the accused person at the site. I don't know as to how the accused person connected with the event. He denied. He said he did nothing. Then Lordship, I came to the Dastamurti Biswas, his mother, Lordship. This is Abhimanyu Biswas is my son. The informant Pankaj Devnath was accompanied the deceased at the time of incident, but I did not know. I did not know the accused person present in the court. The incident occurred about 3 years ago. About 3 years ago, we purchased an Alto car and my son Abhimanyu Biswas used to drive that vehicle. On the day of occurrence of the incident, I asked my son to bring some vegetable from market, and accordingly he went to market. After some time, he returned back from the market and told me that one of his friends wanted our car to take his mother to hospital. I allowed my son to take the vehicle and also asked my son to fill up petrol in the car from his friend. Accordingly, my son went along with our vehicle, but he did not return back till night. I waited for the whole night, but my son did not return back. On the next day morning at about 8 a.m., police brought the dead body of my son. I became nervous and seeing the dead body of my son. I saw many cuts in the body of my son. Blood was oozing out from the wounds of my son. Then pathetic situation arose in our house, and I was very much disappointed. Police took the dead body of my son for post-mortem examination. Police recorded my statement. My son, while he was going out with the car, told me that a friend of village Boha hired his car to take his mother to hospital. It is not a fact. My son did not tell me that one of his friends from village Boha asked him to take the vehicle. It is not a fact that I did not state before the police that my son told before me that one of his friends from village Boha asked him to take the vehicle. And 25, another witness, Ganesh Das. I know the informant Pankaj Devnath. I know the disease of Abhimanyu Biswas. I did not know any of the accused persons. Disease of Abhimanyu Biswas is my brother-in-law. The alleged incident occurred more than 3 years ago. The disease was having also. On the day of occurrence, the incident, one Saddam Hussein Vilas Boha hired village the vehicle of my brother-in-law Abhimanyu Biswas. My brother-in-law drove his own vehicle. When Saddam Hussein and others were sitting inside the car, I saw when I was present in the shop of the market. They went out from my side in front of my shop. Saddam Hussein and others hired the vehicle in one Sunday morning. I came to know that one Pankaj Devnath was also present in the state car. On the same day at about 9:30 p.m., the state Pankaj Devnath called of his father over phone, stating that the person present in the vehicle has strangulated him and threw him out of the vehicle and took away Abhimanyu Biswas with them in the state vehicle. I came to know about the incident. Accordingly, police was informed and he went to the place where Pankaj Devnath was lying. Police and we rescued Pankaj Devnath from the state place. Thereafter, Pankaj Devnath was taken to hospital for treatment. However, my brother-in-law Abhimanyu Biswas went missing. Then we started searching Abhimanyu Biswas along with police, but could not trace him out. In the late night, police traced out the house of Saddam Hussein, but Saddam Hussein was not found in his house. On the next day morning, we came to know from village people that a dead body was lying on a paddy field. I and some of my known person went to that place and seen the dead body of Abhimanyu Biswas, which was lying in the paddy field near Dix. Accordingly, police was informed, who rescued the dead body of Abhimanyu Biswas and took the dead body for post-mortem examination. On being asked, Pankaj Devnath could not tell me the names of those persons who hired the vehicles and caused the death of my brother-in-law. He was Pankaj Devnath could not tell the name of those persons who
He
hired
knew the
vehicle.
name from the police.
Lordship,
The Pankaj Devnath, he has himself said that
Ah.
I could know the name from the police because I saw the accused in
Saddam.
custody, Saddam.
Only Saddam he saw. Only
Saddam.
he identified only Saddam.
There was nobody else at that time in the custody.
No,
Who was arrested at that time when Pankaj had gone?
all are arrested. The police told the name. Police after arresting them told them these are the persons.
No, he had when did Pankaj go to the Thana?
Pankaj go to the Thana, Lordship, around on no, not him. 22/7/2024. Date of occurrence is 20 July 20, 2024. He went to the Thana 22/7/2014.
Where do you get?
Not-
Where do you get this?
Here, Lordship,
no.
one page number one.
On the following date, following day of the incident, I was called by the police. Same date. 22/7 was the Ajahar, same date.
22/7. The date of incident is not 22/7.
21/7.
Yes.
He said that he had performed the last rites.
Yes.
And he said on the following day of the incident, I was called by the police. That means the day he had lost the Ajahar.
Ah.
And then at that time, I saw Saddam. I identified him as the person who had injured Abhimanyu.
Yes.
Police interrogated him, and after that, police told me the name of the accused. He said that he saw Saddam assaulting him.
Yes. He is saying Saddam assaulted. He has seen Saddam assaulted him. Yes.
Yes, then
After that cross-examination part is after receipt of the phone call of Pankaj, I and police went in search of Pankaj Devnath. I told police whatever I knew about the incident. Police came to know about the incident from Pankaj Devnath. When police found him in paddy field, it is not a fact that I did not say before police that I saw Saddam Hussein inside the car when they went out from the side of my shop. It is not a fact whatever I before this call. Here, Lordship, then comes medical position, Lordship. This is of medical witnesses of Lordship Pankaj Devnath. This is I was posted multiple linear central bruised aberration, back and chest, multiple bruised aberration mark over neck, aberration 1 × 1 cm. The injuries are simple in nature. The injuries caused by blunt open. Exhibit 5 is my injury report. I1 is my signature. Process decline. Then page number 28. That is 5 Lordship. He has stated that I know the informant, that this was my husband. I don't know the accused person. The alleged incident took place in the year 2014. The husband was a professional driver. On the date of occurrence and incident, my husband Abhimanyu Biswas went out from the house with his 4-wheeler vehicle, but my husband did not come to the house on the day. On the next day, I came to know that my husband was kidnapped by some miscreants. On the same day, dead body of my husband was recovered by police. My husband used to earn by driving vehicle, and he was a professional driver. After
not relevant, not relevant.
Not relevant, not relevant yet. This is also not relevant. This part, this. Then Lordship PW 31 page number. Page 31, Lordship.
Just a minute.
May I
please.
start with-
Just a minute. What is 29? Qasim?
Or 29. I do not know the informant. and the disease of this test. I also do not know accused person. Qasim Ali. I was, it was, oh, it is, yes, Lord. Yeah, it had taken place in the night time. At that time, the year, there was a rain and floods. One day in the night, I was sitting in my house during floods, and that time I saw one vehicle, that mud truck vehicle coming towards my house, and it crossed my house and went ahead. I saw the flood. I saw that due to flood waters, our vehicle could not go ahead, and it started returning back. On the way back, the vehicle got stuck in the mud. I saw the vehicle trying hard to get out of mud. Thereafter, I saw the lights of the vehicle being put out. Thereafter, one person of the vehicle came to my house and asked for a spade. With the help of their spade, they could release the vehicle from the mud. And after returning the spade to me, the vehicle went away towards the Prang side. In the morning, some boys came to do fishing in the flood water and they found a dead body. Whereupon people collected, but nobody at the time could recognize the dead body. And that dead body appeared to be of the same person of that village.
To be a person not from that village. To be a person not from that village.
Oh, sorry, a dead body appeared to be a person not from that village. Police was informed and police from Jagirat PS and Mayang PS came. Subsequently, the police questioned me and took my name and particulars and recorded my statement. I would recognize the person who had borrowed the spade. I would recognize the person who had borrowed the spade from me on that night if I see him.
Just talking very close, not be able to recognize, but they will not dig the dog, it seems. The representation does it.
Yeah, in the cross-examination, Lordship. May I say?
Qasim Ali may not be very relevant. He saw a vehicle, but he could not identify this vehicle was the one what was used.
Yes, yes.
Number two, he did not identify anyone. Maybe on that day they were on representation.
Hmm.
But on cross, he says that I would recognize the person who borrowed the spade from me on that night if I see him. Maybe they were on representation. They should have been directed to appear and he should have been recalled. Yes, next. PW 12.
PW 12. This is a vital, this is a medical witness, I think, yes. On receipt of summons from this court, I have appeared today with certified copy of the entry register, issue register, receipt register in original. The original entry register, issue register was seized by CPI in connection with other cases. As per record, on 21/7/2020, Dr. R.P. Bora was working as medical officer, Morrigan Civil Hospital. On that day, he did post-mortem examination over the dead body of Oibunna Visa, aged 99 years, male. The dead body was dispatched on 21/7/2024. Arrived
Transverse ligature mark was seen around the neck.
at the reverse
And it is
ligature mark was
continuous.
seen
What
around
does
the
it
neck.
suggest, madam? Continuous,
Continuous, then it's a strength bit. Otherwise hanging.
hanging.
Yes, sir.
It is not continuous.
Strangulation.
Little below the thyroid has to be the
Everything is healthy. Healthy.
Strangulation,
Everything is healthy.
strangulation.
Injury, that is Lordship, regarding muscles, bones, and joint parts, Lordship. Injury parts nil. No injury is state. Disease or disformity nil. Fracture nil. Disclaimer. Head 9. No head.
Head.
9. All witnesses said he was being head on the head, Lordship. In my this is muscle joint injury nil, disease and disformity nil, fracture nil, dislocation nil. Lord. In my opinion, the person died due to asphyxia caused by strangulating, leading to cardiorespiratory failure. Lordship. No inquest not there. Inquest also not there. Inquest not. We have not. May I continue, Lordship?
Just a minute, please.
Fine.
Thank you. PM to substitute. Perfunctorily goes in. Equivalent. How many puts it there again? Interpreter doctor নিজে করছে স্যার জানেন তাৰপিছতো যদি নেম পারফর্মটরিলি করে কি করে লিখি দিব নেম তখন কেন লিখো জলদি Yes.
Yes, Lord. There is other absence of other physical injuries also, Lord, on the victim's body that would indicate a struggle or violent assault, which is a forensic ambiguity. There is a ambiguity in the forensic part, Lord. No, nothing was done by the police. And again, Lordship, the crucial evidence part, evidentiary part, Lordship, here, page number 33, Lordship. The IO. May I read, Lordship? Here, on-
Just a minute. Who is this doctor? Nabin Bhuya?
Naveen,
How is he connected?
yes, Lordship, he represented Dr. R.B. Bora by producing.
He did not do the PM.
He died, Lord.
Huh?
He died postmortem. He died actually. I think as per record, doctor the examination and that what you have. Somewhere it is written the doctor died. I've seen lots of doctor died. In the cross examination part, Lordship, I joined more in the documents brought by cause of that was not mentioned. I could not trace the third copy of the PM report. Yes, Lordship, this is a one type of perfunctory investigation also, Lordship. There is no forensic part, ambiguity is there. No forensic was done, nothing is done. Now the fingerprints also was not done. Okay. Huh?
Thereafter, what happened?
Thereafter, page number 33, Lord. The main IO, Lordship. Huh? On 21/7/2024, while I was posted at TSI Jagi Road PS, on that day I was performing patrolling duty at Jagi Road area. Ajit Nethar, that Ajit, along with two others, informed me that one of his vehicle was taken by few persons on hire, and the vehicle and the driver was killed. His nephew Pankaj Devnath was assaulted, who took shelter at village Borjari. On getting this information, same was entered in the GD entry book number 610. And after informing the matter to the OC target place, I went to the Borjari village with the informant to investigate the matter. Accordingly, at about 1 in the midnight, I arrived at the residence of Rajan Bora. Don't know who is Rajan Bora is. At Naohoria village, and recovered Pankaj Devnath with some injuries. He and Rajan Devnath were interrogated, and again, is Rajan Devnath, they are saying. With Pankaj Devnath, I returned to Zagirat PS and provided treatment to Pankaj Devnath. At about 2 a.m. on that night, by Pankaj Devnath, I, along with OC, came to the place of Bhakatgaon, Mayong Road, where Pankaj Devnath was thrown away. I have drawn a sketch map of the state place and Exhibit 7 the sketch map of the state place. On that day, at about 9 a.m., OC Zagirat PS got an information over phone that from Ganesh Vistas that one dead body was lying in Nektera, Abi area. On getting this information, I, along with OC and other police personnel, went to that place and found that by that time, Mayong police personnel arrived there and recovered the dead body. Dead body was identified as of Abhimanyu Vistas, driver of an also vehicle by his relative. I have drawn a sketch map of the state place. Exhibit 8 is sketch map of the state place. Exhibit 8 was in my signature. I have recorded statement of Kasem Malik, a nearby resident. The place where the dead body was recovered has fallen under Mayong PS. Mayong PS has sent the dead body for
PM.
examination. Inquest on the dead body was also done by Mayong PS. Here he has stated inquest. It was not exhibited, or I don't know whether it is in the record or not. He said inquest on dead body was done by Mayong PS. That prosecution will say whether inquest is on record or not. While we were, but it was never been exhibited, and we are not being given to the scope of cross-examining it. That part was. While we are at the place, I received a secret information that secret information is never been exhibited. That Moinul Haq, Hussein, Saddam Hussein, Saidur Rahman, and Buraburi area were involved in the crime. During return journey, we searched the houses of above 3 persons, but did not find them in their house. Subsequently, basing on some information, on that day at about 10 p.m., we could apprehend Moinul Haq from his residence. During interrogation by police, Moinul confessed. Here, lordship confession part here. Here they say that Moinul confessed that he, along with Shahjahan Ali, Dimapuri, and Saddam Hussein, took all the vehicle on hire from Jagirot for going to Akasi Ganga under Daboka PS. While going, the driver picked Pankaj Devnath in the vehicle. While going, they also picked Saidur Islam and Ibrahim in the state vehicle. While returning from Akasi Ganga, they came to Poha under Mayang PS, and during journey, after consuming beer, kept the bottle in the vehicle. It is also stated by that driver, Pankaj and Dimapuria was sitting on the front side. During going across, Saddam hit a beer bottle. On the head of the driver. That the disease victim. On going senseless, Shahjahan Dimapura took control of the steering wheel, and seeing all this, Pankaj get down from the vehicle by opening the door. Saddam and Moinul chased Pankaj. On pretending dead Pankaj, they assaulted Pankaj on the stage. Presuming him dead, Moinul and Saddam boarded the vehicle. By that time, Ibrahim and Saidur get down from the vehicle. Subsequently, Saddam, Shahjahan, and Moinul took the vehicle with the dead body of the driver to Nahatehat and throw away the dead body. The vehicle stuck there. This part was never been proved. The vehicle stuck there. To get the vehicle free, they went to the house of Kasem Ali and collected one spade, and clearing the road, they took away the vehicle from that place. By taking the vehicle from their vehicle, they went to the vehicle and handed over the vehicle to Baharuli Islam and Ruful Amin of the Parsula Kasaribira under the Horchat case. On knowing this from Moinul, on the midnight hours, I, along with PS personnel, went to the Kasaribira area under Lahore with Moinul and searched the residence of Ruful Amin and apprehended Rohul Amin. Here, lordship, here the main fact is that he said
We think we'll have to rise today now. There are some administrative jobs. Tomorrow is a holiday. We'll continue this. Madam is also have to prepare. Tuesday, mark your fix for us. No, এটা পড়া নাই। এই যে HR চৌধুরী আছে, এরই আছে। এটা আছে নাকি? এটা 19 টা tag নাকি?
Thursday,
Or Wednesday also we can try.
or Tuesday.
Oh, yeah, yes. Likhi. Paucity of time did not permit the matter to be taken up wholly. Para. List for hearing on 20. Okay.
So can it be part heard, Lordship?
We're not saying part, let us see, we'll remember. 20 will give preference to this matter. আসেনি মানুষ। They did, yeah.